Morning. Any matters before the jury? Mr. Phillips.
No, Your Honor. I think Sean Ford did want us to ask that as far as any of the arguments regarding jury instructions, wait until we finish with the witnesses or if they're in break. Go ahead and get started this morning, Your Honor.
Said any enlargement? Is that the word you said?
No, Your Honor.
What did you say?
It
It's like you said any enlargement.
No, argument.
Argument. Okay, I've got you. Okay,
But if we're all on the same page, we'll go ahead and keep it rolling.
sure.
Thank you, Your Honor.
All right.
Your Honor, if it's possible, prior to the jury coming in, if Your Honor has proposed some jury instructions I could review during the testimony, I'd love to have them.
I don't. Mr. Phillips has submitted some, and
Thank you,
State
sir.
has submitted some. You can, if you like to review some from a previous case,
Your Honor, standard charge, yes, sir, that's what I'd like to review.
and some may or may not apply to this case because we haven't gone through them, but I don't intend to give them written charges. So. Let's give them back to him. She can make a copy of those for you if you want to. She can copy those for you if you just want to have a copy. Strike through the word.
Yes, sir.
You may bring the jury. Give me the original back. Thank you. Now I'm good. There you go. You can have these back. Good morning. Welcome back. Day number 4, defense's case. Mr. Phillips.
Good morning, Your Honor. Thank you.
Yes, sir.
Defense would call Jason Chapman.
State your name and for the record.
Good morning. Again, my name is Captain Jason Walker Chapman, last name CHAPMAN.
Officer Chapman, you testified previously to the jury, well, on the first day of trial, is that right?
Yes, sir.
And you were sworn under oath,
I was.
and you specifically, under oath, told the jury that you cannot get that vehicle to flash the park lights when the vehicle is running. End of story. That's your quote.
Could not get the vehicle to flash the park lights when selecting lock or unlock. Those are my words.
Oh, okay. I went and watched the video, so I know you don't say unlock or unlock. Quote, you cannot get the vehicle to flash the lights when the vehicle is running. End of story. You said, we ran the test many times. Quote, if the lights are flashing, it can't be from that key fob. Those are your words.
If you say they are, I know that during that testimony, at some point in time, I was very specific about the fact that that's in regards to lock or unlock.
All right, well, let's go through that, because
Okay.
y'all spent painful detail to show this, and I know that's part
Sure.
of the argument. Dylan, we can do this one of two ways. I can either hook up my laptop, or you can help if you don't mind. All right, if you go to 1645:33. To give kind of an overview and what we'll see on the video, essentially, y'all went through the testimony after you watched the full surveillance cam video, that night owl DVR. And you said,
Mr. Are you posing a question?
yes, Your Honor. So he
You must
understands.
restrict it to a question.
Yes, Your Honor. It's context for him, so he understands what
No,
I'm
you
asking.
must pose a question.
Yes, Your Honor. And so with that, and this is the 1645. All right, well, if you go ahead and play it. And so whenever Solicitor Stone played this video for you, we're seeing both Rita and Larry try to open the vehicle, and they have the key fob. As Rita comes around the vehicle, she has the key fob, and she's hitting it towards the car, and you see that around 1645:33, and it basically nothing happens. In other words, like you said, that it won't flash when you're hitting unlock or lock.
I didn't understand the question.
Right here, you see her hitting the key fob?
I see her holding the key fob in her hand, but I can't testify that she's pushing the buttons.
All right, well, I mean, you can walk up there and look close if you want.
Trust
Sit
me,
there doing
Mr. Phillips, I have looked at this video extensively.
Understood. Can we roll it back? So you're saying that she wasn't hitting the button, she's just staring?
No, sir, I'm not saying that. I'm saying she has in her hand what appears to be the secondary key fob that they retrieved from her residence off of Academy Road. I agree. And she does have it in her hand, and she does have it pointed at the vehicle, and she's making a motion with her hand, which would indicate that she may or may not be pushing the buttons. I just can't tell you she is.
Fair enough.
Thank you.
All right, so she comes back. Again, this here, she's pointing it. The jury can make up their own mind. They can see her doing what she's doing, and they need a chance at the appropriate time. They'll have the opportunity to stand right in front of the vehicle.
Mr. Phillips, you must ask questions, not give commentary.
Yes, Your Honor. And so, at 1646:08, Solicitor Stone asked you to go to 1646, and that's when Rita hands Larry the key fob, and he's hitting the key fob repeatedly, and your testimony was, quote, cannot get the vehicle to flash the lights when the vehicle is running, end of story. Then you say, we've tested it many times, I can't recreate it. Quote, if the lights are flashing, it can't be from that key fob. That's your testimony. That's your words.
If you're saying that's exactly what I said without any of the context or post comments, then so be it. But I stand by the fact that you cannot, if the vehicle is running in direct correlation with lock or unlock, you cannot get the vehicle to flash the lights.
All right, so you'll concede that it will flash while the vehicle's running.
There are ways to make the lights flash with that key fob, but not in regards to pushing the lock or unlock button.
And we're about to see it in a second, and then we'll get there.
Are you asking me if we're going to see it?
Yes, sir, I promise.
Okay.
And so if we could go to 164608, and this is where you said, look, the lights are flashing.
Sure.
The lights won't flash if the vehicle's running. So he hands, the key fob gets handed to Larry. Larry's fumbling around with the key fob, hitting all the buttons there, or maybe not. I know
Sure.
You'll fight with me on that. And then there's the lights flashing. You're saying there's no way those lights will flash like that if the car's running.
Now, right there is not the same point in time that Solicitor Stone and I discussed.
Oh, we'll get to it, and I got that.
Are you, hold on, you can't ask me something and run off from me. Do you want me to answer that question?
Go for it.
All right, right there, those lights are not flashing in response to pushing the lock or unlock button. They're flashing in response to pushing the panic button on the side of the key fob. The difference is the style of flash and the pattern. The key fob, when the panic button is pressed, it will flash regardless of whether the vehicle is running or not running, as long as the vehicle has power. The difference is it is a very patterned, systematic flash. No matter how many times you press that panic button, it will flash in this pattern. You can't hit it 3 times and get it to stop and start again real quick. It will stop at the end of that pattern and pick up again at the next pattern. What you saw there was 1, 2, 3, I can't remember if it's 3 and 3 or 4 and 4. Those are responses from the vehicle and the fob to the panic button being pushed, not the lock or unlock.
And that's what you told this jury? Because I'm going to pull the video up of you testifying.
No one asked me that question.
Okay.
We were talking in regards to lock and unlock, and I encourage you to pull the video up because I'm very confident of what I said.
Okay. And so with that, the other time it flashes is when they pop off the handle when they're on with Stokes lock and key and manually turn it. It flashes.
There's
again.
another set of flashes between this set and when they actually get the door unlocked.
And your position is it's not the panic button.
That series after this, prior to the final set of flashes when the vehicle is unlocked, because you can physically put the key in the lock,
And it'll flash.
and when you lock or unlock the vehicle, it will flash, but that is not in response to pushing the lock or unlock button. That is physically turning the key. And we know by what they've stated and what we see on the video, the only time the key was actually placed into the key on the door, and that's the only key location on that 2012 Volkswagen. If you turn it left or right, yes, it will flash in correlation to lock or unlock. But the series after this and prior to that, my testimony was that cannot be done with the key fob because it is not the same systematic patterned flash that the panic button shows.
Actually, let's mark this as an exhibit. Thank you. And Your Honor, what I've marked is a flash drive that looks to appears to be Defendant's Exhibit 15. 13. Sorry. And you were there when the tests were conducted. That's what you testified to,
That's correct.
right? And y'all made a video of those tests.
We did.
you see how, I don't get your question. This right, if you're looking at this right white part light's out, right? It's not on.
Agreed. The daytime running lights.
That's what, there you go. It's out on this side, right?
It is.
Okay. And so this is looks like the video of the test y'all did on the video?
Yes, this is video of the very last test that we did prior to trial.
And the vehicle is running? We'll see.
Yes, it is running.
So you see the one light's out, the one light's on. Appears to be at a hard reset. You see 12 a.m. on the clock.
Dead battery.
So this is, can we get the entire front? Can we go this way? Right?
So this is test car running, lock running, vehicle not flashing. So that's what you just testified to. If you try to unlock or lock it, it won't flash while it's running.
That's correct.
All right.
With the fob and not using the hard key.
That's right. So just to make sure that everybody kind of understands it. Yeah, there you go. So while the car's running and you hit the key fob, unlock or lock or unlock, it's not going to blink.
That's correct.
It's not going to flash.
That's correct.
But when you hit the panic button, it will flash.
Regardless of whether it is running or not running.
So this is, can we get the entire front? Can we go this way? Right?
So this is test car running, lock running, vehicle not flashing. Unlock, will not flash. Panic button, will flash. And when you turn it manually, it flashes.
That's correct.
All right, thank you. Your Honor, at this time, I would move to admit defense exhibit number 13.
Any objection?
Without objection, Judge.
It's admitted.
And dealing on this video, so 11:08:09, I think. Towards the end of the day, sorry. Yeah. And this is you, this is the testimony.
Yes, sir.
So a minute ago.
Could you let
ju-
it go just a little further? Because
Sure.
I know what you're going to ask me, and what I'm trying to explain to you is that you're not showing the same video clip. And in that clip that the solicitor showed at that time is not the same one where we're seeing the pattern flash. And yes, I see what you're asking me, but you're leaving out the pretext of this conversation and whatever else was said, where I'm specifically mentioned in regards to the lock or unlock button.
No, they were here. They know what he said. They just watched it.
The witness has not been questioned, he's just making a speech.
It's fine. They know what he said.
I have an objection.
Yeah, well, the objection is sustained as to all commentary by everyone. The role of the lawyer is to ask a question and to give the witness an opportunity to respond to the question. It's not the time to give speeches in the middle of a question or commentary in the middle of a question by the witness or by the lawyers. Proceed.
Thank you, Your Honor. But your quote, and I understand you disagree with me, but your quote is, "You cannot get the vehicle to flash the park lights when the vehicle is running." End of story. Your words.
I can't argue that in that particular video, right there at that moment, yes.
Your words. If the lights are flashing, it can't be from that key fob.
I'm going to answer it again. Yes.
Thank you.
You're welcome.
No further questions.
Mr. Joy.
It's
Mr. I'm
Captain.
sorry.
Yes, sir.
Yeah, I don't have any questions for you. Thank you.
Thank you, sir.
By the state.
Thank you, Your Honor.
Captain Chapman, one of the things you said was, that you said on that clip, well, first of all, was that the only time that you testified that day? In other words, that clip, was that encompass all of your testimony?
It is not. As I recall, I think I was on the stand 6 hours.
During that 6 hours of video watching and testimony, just to clear this up for the jury, at some point did you specifically say, you did specifically say that that was with regards to lock and unlock?
I did.
And to clear up any confusion, that's what your testimony is today, correct?
That is correct.
And when you said I couldn't replicate it, I believe you're talking about the pattern, aren't you?
When I answered that question at that moment, it was in reference to the video that was being shown at that moment, in which, and you heard me discuss it that day, where you had a quick flash of 2 flashes, followed by a separate single flash. That's what I was referring to. I cannot replicate that, which is significant or implies lock or unlock if the vehicle is running.
In other words, you can't replicate that pattern on the panic button.
No, I cannot.
So let me ask you something else. The video that Mr. Phillips just introduced, were you present when that video was created?
I was,
And was that video then turned over to my office?
immediately,
And then did I, to your knowledge, turn that video over to Mr. Phillips?
immediately.
Your Honor, court's indulgence, please, for just a second. Captain Chapman, I'm going to ask you to review this section of the video. So the different are those the flashes, the later ones that you're referring to? or
That
they're
was the
even-
whole series, the series that Mr. Phillips showed, and then the series that was previously shown to me on Wednesday, I think it was.
So, just to be clear, it's your testimony that, that when you press the lock and unlock button,
Your Honor, objection, the meeting's getting a little out of hand.
well, Judge, I'm on cross-examination, I'm allowed to lead.
Withdrawn. I've withdrawn the objection. I think he is on cross-examination and allowed to leave.
Your testimony is that when you press the lock or unlock button, it will not light those, for lack of a better word, park lights, if your car's running.
If the vehicle is running or if the accessory switch is turned on.
And your testimony is based on all the things that you just saw, during that series of flashes, that you could not replicate that pattern, that initial pattern of the same flashes when you press the panic button.
That is correct. That the last ones we saw there, no matter how many times we try it, we can't replicate that pattern. We can replicate the pattern shown by Mr. Phillips, or the beginning of that series, where you see 3, and then it stops, and you see 3. That's the standard flash pattern for pushing the panic button. But the second and third volleys there, or excuse me, third and fourth volleys, you see where you have the quick flash and a pause and a flash. That is signifies unlock and lock. And
Is that what you're talking about when you testified? And I think Mr. Phillips played this clip when you said you couldn't replicate it. You're talking about replicating that pattern with lock or unlock, or replicate that pattern with the panic button.
that's correct.
I don't have any further questions.
Mr. Phillips.
Thank you, Your Honor. The other night, I asked you about, there's no report in this case and notes, and you said you had notes. They never gave me any notes. They said the video was the notes. You're testifying to all this now about all this other stuff, but there's no documentation that's been provided to us to substantiate anything you've said.
Are you asking me a question
Did you
again?
give them the notes?
I gave them the video. When you asked me specifically on the stand, but you ran through, did you do a report? Did you write notes? Did you do it? And I said, yes. And as a matter of fact, we did that 3 times because I had to say, am I going to have to keep answering the same question? Yes. And then we got very specific, and we said we videotaped it. And you told me that you didn't have it, and that's not on me. The video, as we just explained, was filmed. I was present. It was turned over to the solicitor, and as far as I know, they immediately turned it over to you. That is my documentation.
Well, that's not the way it worked, but I said notes, not a video. Y'all did that last Friday on August 18th.
We did it on, that was the final time that it was done. That was the time that we did the notes.
Okay.
You didn't ask
Keep
me
saying
written
notes.
notes. You didn't, I mean, do I
Handwritten
need?
notes.
Okay.
Did you do
then,
handwritten
I
notes?
didn't do a handwritten note on the 18th. I did not.
You do a report?
The video is the report.
No further questions.
Thank you.
Anything further?
Briefly.
Or just first? By,
I apologize.
all right, go right ahead.
Thank you, Judge. When y'all got to the scene, was the air conditioner on the car running? Was the car on?
The car was on. The air conditioner was running, and the air conditioner was cold.
Because there was testimony earlier that I believe that one of the defendants in this case, specifically Mr. King, had reached in and turned the car off. When y'all got there, was the car running or off?
The vehicle was running. The air conditioner was cut on. The ambient temperature inside the car was not cold, but the air conditioner was blowing cold air.
All right, let me back up for a second. So the car's running, the
Yes.
air's blowing cold, but the car's hot.
That's correct.
Like maybe it was just turned on.
Speculation. That's just
Withdrawn,
That's
Judge.
ridiculous.
The jury is to disregard the question and disregard the comment. You may step down.
Thank you, Your Honor.
Next witness.
Elizabeth Clyde.
Step right up, ma'am.
Hello, my name is Elizabeth CLYDE, C-L-Y-D-E.
Good morning, Ms. Clyde.
Good morning.
If you could, tell the jury a little bit about yourself.
Yes, my name is Elizabeth. I am a high school teacher in the Berkeley County School District, so just about 50 minutes away from Walterboro. I grew up here. I am happily married to my husband, and together we are pastors at Faith Church. We don't have kids yet, but we have a really sweet doggie. And yeah, I'm the daughter of Rita Pangalangan.
I was going to say, what's the relationship with Rita?
It's my mom.
And you're how old?
I'm 31.
Now, tell us a little bit about your mother.
Yeah. So, born and raised Walterboro. She raised me and my younger sister. So I was in the house for a very long time when we brought Cristina home from the hospital. She was the miracle that we've been praying for. It was very hard for my mom to get pregnant again after me. I was a little complicated. And so I stayed home, went to a local college. And even after I got married, I kept really strong relationships with my mom. Coming home on the weekends, all the holidays, we would drive back and forth and see each other so I can hang out with her and Cristina.
And so you were around for Christina's whole life.
Yes, I was the one that she looked like. She was my special person, 5 days birthday difference, so we shared every birthday together.
And what's the age difference?
Only 13, 14 years.
And so would you consider yourself part of a caregiver for her as an older sister?
Yes, Mom and I, we had the plan in place. When she got too old to care for Cristina, we already had a plan in motion for when I would take over.
And again, could you describe your mother's relationship with Cristina?
Loving, Cristina never heard the word no. Every single month, every single time we went out to eat, we lied and said it was her birthday because she loved being the center of attention and she loved music, so we always lied to get that happy birthday song sung to her. And then people at Shoney's, they kind of knew us, so they knew our facade, but they were always happy to play along with us.
And how would you describe your mother's parenting style?
She was the fun parent. She was the one that I always went to with all of my problems. She cared for us so much. Dad worked all the time, and with her being a school teacher, her schedule aligned with us, so not only did we get to do all of the sporting events and any activities, she was at every single one of them, and she made sure we got to do anything we wanted or anything we wanted to try. She always encouraged us for any sports, even if I didn't stick to it. She always let me restart and try out new things.
What kind of special accommodations had your mother made for Cristina?
Yeah, oh my gosh, so many. We always joked that Cristina took my title as the bougie one in the family, because when we did her bathroom remodel, not only was it all pink and door related, but because she loved the pool and hot tubs and bubbled, we had to splurge. Even though I told Mom it was way too much, she splurged for the jetted tub. And we had to get the bathroom widened so her wheelchair can fit into it, because since she was getting so big and so heavy to pick up, we had to have that special tub so she could just slide in from the wheelchair into the tub. And we got hardwood floors all throughout the house so she can use her walker. There was a wheelchair accessible ramp we had installed, and right before school started, she was just fitted for a brand new wheelchair for the beginning of the school year. So
how
all the
soon was
accommodation.
when this tragedy happened, how soon was she fitted for that wheelchair?
we were supposed to pick it up like in a week or two right before school started, so it was done just a month or so prior, the custom fitting, and Mom was currently saving up for a brand new wheelchair accessible van because her last one, the transmission just went out.
How would you describe your mom's character? Who she is as a person?
Was she a good person?
No, how would you describe her character?
She was my role model. One of the reasons why I'm a teacher was because I saw her impacting lives of so many students. She loved us so much, even when she dropped off me or my little sister at camp, even if it was just for 5 days, she cried every single time. And she would write letters before we even left for camp, so that way the next day we had something meal time to look forward to. Even after I have got married, she would send care packages and coming back and forth to the house. She always made sure I had everything I needed. She would always wanted to, I raided her closet and her pantry many times. And she just always made sure we had the best possible. She loved me, but she still loves me so much. And like, she's just so kind and caring and loving. Yeah.
I know it's difficult. After you moved out, how often did you visit?
Very often, since it was only like a 45-minute drive. So I would come home on the weekends, and then I would come home for church with her and attend Nova for like Mother's Day, or if we had a special event at church, she would come with me. So we attended church together, even living separately quite often. And of course, I always got a free meal when I came home, so I came home often.
Your Honor, may I approach?
Yes, sir.
I'm handing defense exhibit number 5. Elizabeth, what are you looking at?
That's my mom, my sister, and me. The Boo Bear is what her nickname was.
And how would you describe what was going on in that picture?
Well, it was so hard to get her to smile for a picture because she was not photogenic at all. And so I'm sure it's my husband probably behind the camera doing a stupid dance or trying to get her to smile just for that picture to be taken. But I mean, Mom's holding her so tight. She was Mom's whole world.
Now, at this time, we would move defense exhibit 5 into the scene. Well, I provided everything to Sean. Sean had it. Sean said he had it. Could I see the picture, please? Okay. That's all. I don't have any objection, Your Honor.
Do you have additional photos that you are going to post? If you let them review all of them now?
I provided a flashlight.
I understand. Would you let them see all of them now?
Yes, Your Honor. And I did that this morning.
Would you let them see all of them now?
Thank you.
I don't have any objection, Your Honor.
Each of the photographs are admitted without objection, if you have them marked.
Yes, Your Honor, we do, and that's defendants. Bound court got it, thank you.
Tell me the exhibit numbers.
Yes, Your Honor. We had three through 12.
Very well. May proceed.
Thank you, Your Honor. Actually, if you could, we'll just kind of go through. Through the pictures.
So this picture was at Christina's Special Olympics. Mom and her actually won the wheelchair race because Mom literally fell down while pushing Christina over the finish line, so they would win. And it was just, I mean, they match, full of happiness. Christina and I, we also had like matching clothes as well, even though we were 14 years apart. It was just fun to be sisters together. And then this was after church one Mother's Day. They came to my church that Mother's Day since I married someone on staff, so it was a pastor on staff, so it was hard for me to leave, but that's when she just started coming to our church very consistently. So this was actually taken in my in-laws' backyard, and we just got done with family lunch. We just went over this one. Okay. Oh, this is when we all went to the aquarium together, and her hair was always a hot mess because she didn't get the good Asian genes like I did, but her hair was always so bad. But this is us at the aquarium. We always try to do anything and everything with Cristina, whether it was maintaining to the pool or going to the aquarium or going out to eat. This is their first place ribbon for that wheelchair race I just described. And this Whirling Water had door at Wanamaker, and so if we could put a Dora store to shame with as much Dora. Her room was decorated in, book bag was Dora. Often went to Disney and Nickelodeon, and we loved going to Disney with her because her being special needs, she was treated like a princess, and I took full advantage of all the line cuttings with her. And this is just a collage probably I made of her because Mom loved having pictures everywhere, like wall-to-wall pictures of me and Cristina, just everywhere. It was her treasure because she always says that her kids are the greatest gift from God. And then this was at my wedding. Because Cristina couldn't walk, she was pulled in a wagon with bubbles because she loved bubbles. So instead of throwing flowers at my wedding, she came and throwing bubbles. And it was just really sweet. And I think we're back at the beginning.
Thank you.
Oh, yeah, okay.
How would you describe your mom's house? Was it dirty?
No. She was a clean freak.
Did it have food for your sister?
Yes, I stole it often. I stole all her gummies and snacks, and one of the reasons why we got hardwood floors was so Cristina could be independent and eat on her own. Like she was able to take bites, very slow bites, and eat and feed herself. So often her favorite was chocolate donuts. So we would just let her have a chocolate donut while watching Dora, and she would make as big of a mess as she could because we would clean it up always.
And they had primarily Pediasure. Was their primary somewhat diet that she had?
Because she could swallow so little, that was a big portion of her like nutrients. But she ate chicken, she ate meat. It had to be like small bites, but for because she had a thing where she would drool all the time, so she always got dehydrated. So Pediasure was her main hydration, not really her main source of like nutrients and food.
So there's generally a stack of them in the house.
Yeah, she would get them in bulk, like the crazy coupon lady.
Now, Brittany Honeycutt, she's a former roommate of your mother. Do you know her? Mm-hmm. Could you
Yes.
Could you just describe how you know her?
Yeah, so I know she rented a room with Mom just for a small season, and when I would come, I know Mom showed me her bedroom like once or twice before, just because Mom was complaining it wasn't clean, but I didn't really have that much interaction with her. She didn't stay very long.
And why didn't she stay very long?
There was just a lot of fighting. Mom quickly realized that it's very hard to find a good roommate, to pay on time and to be clean.
And so I guess the main issues was that she wasn't paying her rent and she had moved in. I don't want to put words in your mouth. Do you know about that?
Yes, sir.
Could
And
you
then they
explain?
trashed the room when they were gone too. Like she had to like fix damaged walls. I can't remember if there was hardwood or carpet in the floors, but I remember we had to like clean the floors heavy after she left.
And she didn't just move in, even though she was some people came with her, right?
I think well, she was supposed to move in, but I think she brought a boyfriend along that wasn't a part of the agreement down the road, and then that caused a lot of drama.
And so just to make clear, as far as your mother's house, was it fit for Cristina?
Yes, we got the walker for her, even though insurance wouldn't pay for it. They said it was cosmetic, so mom would work extra tutoring jobs. She would clean houses. She made sure Cristina had whatever she needed because the insurance often dubbed something unnecessary or cosmetic. So she made sure Cristina had above and beyond what she needed.
Did your mother have a lot of support?
No. After the divorce and my dad left, well, and the money left too, a lot of people went team dad.
And with that, as far as you can describe your relationship with your mother. Has that changed at all?
No, we've been together since I was born and we'll stay together.
And leading up to this tragedy, was there any red flags that you saw, anything that was out of the ordinary?
No, none at all. Like I said, we were so excited for Cristina to start school. Again, we were, her book bag was prepped. She just got her physical done at the doctor's, giving her the clearance to go to school. She had her matching door, her like 15th door doll that she has gone through to attach to her wheelchair. But like I said, we were supposed to pick up the new wheelchair right before school started.
Had you ever known your mother to leave Cristina in the car?
No,
You've never seen that?
no,
Never heard of it?
no, sir.
All right, this is final opportunity. You can tell them whatever you want them to know about your mother.
My mom, she loved Cristina so much, and she's a good mom. She would often say that God created her to be Cristina's mom because she was tough and she could handle it. And she loved Cristina so much. She loved her so much.
Thank you. No further questions, Your Honor.
Yes, sir.
I have no questions for this witness.
By the state.
Just a few.
Is it Reverend, do I call you Reverend?
Oh, no, sir. Just
Okay.
Elizabeth is fine.
Okay, Elizabeth, thank you for being here, and I saw the photographs. You have, I guess, been out of the house since you were, in high school, I guess?
College, about 20,
Okay, and you've been married for how long now?
about 10 years.
10 years, and you live where exactly?
I lived at Somerville at the time.
In
Yes, sir.
Somerville? Okay.
So just 45 minutes away.
I went through the photographs, and I did not see any pictures in the photographs of Larry King. Did you spend any time with your mom when she was with Larry King?
Yes, sir. We went to church together as well, some.
Did you ever spend any time with your mom when she was doing meth?
No, she didn't even drink alcohol.
So you didn't know she used meth?
By use, what do you mean?
Like-
With what I know, her character, that was one of the main reasons why she and my dad got divorced, was because of drugs.
Okay.
And she never used meth or any kind of drugs. I mean, she likes her cigarettes, but she wouldn't even touch alcohol at all.
The house that you talk about, your house, was appropriate for Cristina. What about Larry's house?
I've never went to Larry's house.
So you don't know if Cristina has a bed there, what she sleeps on, anything like that?
Objection's overruled.
So, thank you, Your Honor. So you don't know where she slept or anything like that when she was at Larry's house?
I would never ask those questions. It didn't come up in conversation.
Okay, all right. And again, so as far as you know, you don't know what goes on in Larry's house when your mom is over there, and you don't know anything about her using meth?
No, sir.
Okay, thank you, ma'am.
Mr. Phillips.
Do you think your mother would do anything to kill Cristina?
No.
She loved her.
Yes. She loved her. Cristina was her whole world. And she has not been the same. Every single day we've lived with missing Cristina.
You wouldn't be up here if you thought she intentionally did something.
No. I stand by my mom.
Thank you.
Anything further?
No, you don't.
Thank you. You may step down.
Thank you.
Ladies and gentlemen, we'll take a break now. Please go to the jury room. Please do not discuss the case. All right. Mr. Phillips, who's your next witness?
Fence restaurant.
All right. Okay, we'll take a few minutes break and we'll discuss the jury charges. We'll have you rest in the presence of the jury. Does the state intend to offer any reply testimony?
No, sir.
All right.
And Your Honor, for the record, I think procedurally, I hate the shell game, but I have to renew all prior motions, the mistrial motion, all the prior pretrial objections, rulings. I have to renew all that at this time.
Yes, sir. Any thing from Defendant King?
Your Honor, likewise, we renew our earlier motions, including our motion for direct verdicts, but that does nothing new.
And reply by the state.
No, sir.
I think we've covered those bases.
Okay. These are jury issues. The motions are denied.
Thank you, Your Honor.
Yes, sir.
All rise.
requested charges. Yes, sir, from the state.
Your Honor, we had previously handed up, and I can hand you up another copy if you need it, 4 states' request to charge, one as to malice, a second one as to voluntary intoxication, and if I can take a brief pause on that one, Your Honor, you had asked us to find case law one way or the other. With Your Honor's permission, I'll hand up State versus Todd, which is a Supreme Court case from 1986. In State versus Todd, it's a shooting case where there was evidence introduced that the defendant had consumed alcohol, and it's pretty much the exact same argument that was made in this case, I believe by Mr. Phillips, and I think it was joined in by Mr. Lloyd on behalf of Larry King. In that, well, we didn't raise that as a defense, so it's not a proper charge. What State versus Todd says is that
If you,
the evidence should. Yes, sir.
if you don't mind, give me a moment to look at it.
Yes, sir.
So that, all right, you may continue.
Thank you, Your Honor. And I'm sure as Your Honor saw, it's actually on page 404 on the last page. Appellant also alleges the trial judge erred in charging the jury on the law of voluntary intoxication because intoxication was not a defense. The law to be charged is determined from the evidence presented at trial, and that since there was some evidence showing the appellant had been drinking prior to the shooting, therefore there was no error in charging the jury as to voluntary intoxication. And Your Honor, I would respectfully ask the court to consider this. Otherwise, there'd be no reason for that jury charge because no lawyer is going to get up and argue that as a defense because it isn't a defense in South Carolina. But what we have to do is make sure the jury understands that as a matter of law so that they don't make an incorrect ruling. And the solicitor said something when we were talking about this, I believe yesterday, that kind of struck a chord, which is just like mere presence. None of us have gotten up and said that just because they're merely present, they're guilty of the offense or could be guilty of the offense. But obviously, we're not objecting and have included mere presence in one of our, I think in the hand of one is the hand of all charge, that mere presence cannot be considered by the jury as enough to convict him. So I would respectfully ask the court, based on State versus Todd and the other reasons cited, to respectfully deny the motion by defense counsel that not be charged to the jury.
All right, Mr. Phillips.
Thank you, Your Honor. The charge in this case wasn't actually listed, the specific language. However, the court does say they find no prejudicial error in the trial court's charge to the jury on the law of voluntary intoxication, but they don't say whether there actually was error, just no prejudicial error, which depends on the facts of the specific case. In this case, I made pretrial arguments under 404B, 403, specifically challenging the admissibility of the intoxication testimony and evidence. And so we have no idea whether the lawyers properly preserved those issues in this case, and we don't even have the language that's charged provided in this case. And so it just says no prejudicial error, which could be harmless error. It's a 4-page opinion or something like that, from 1986 that doesn't provide any other specifics. So based on that, because we don't know that the lawyer made the same arguments, the prejudice can be different as far as their analysis. And so that's the distinguishing factor, in my opinion.
Mr. Lloyd. Mr. Lloyd. I'm sorry.
Your Honor, I haven't need to be heard further, but I'll go with Mr. Phillips.
I find that it's a proper charge, given the evidence presented in the trial.
Thank you, Your Honor. Your Honor, we had two others that were States 3, which was the law of conspiracy, and States 4, which is a combination, actually. It is, I think, something the defense had asked for, which is a mere presence charge. Proof of mere presence at the scene of a crime is not sufficient to find someone guilty, and then goes into the law of the hand of one is the hand of all. So that we would renew our request for Your Honor to charge those four, and again, if I need to hand up another copy, Judge, I can. And then I do, at the appropriate time, Your Honor, I have objections to the one that Mr. Phillips sent out last night.
You all really think this brain can, I'm trying to focus on your charge, and now
Yes, sir.
you're telling me about your objections. Just focus on your charge, your requested charge.
Yes, sir. Those are the four that we would respectfully request the court to charge.
Number 3, conspiracy.
Yep.
Says the defense.
As to the conspiracy,
Yes.
I think it's a correct statement of the law, Your Honor. I don't have an objection. If Your Honor has a conspiracy charge in conjunction with it, I'm fine, but I think that this is correct, and I don't object to you including this language.
Mr. Phillips.
With the malice charge, specifically looking at it, again, what I presented as far as what I believe to be the proper malice charge, where it says.
We're talking about request
Oh, I
to
apologize.
charge conspiracy.
That's fine, Your Honor. No objection.
So we'll charge number 3 as conspiracy, as requested. Of course, I will not reference any statute number. Request number 4, mere presence.
Your Honor, that was my verbal request. The state has requested it also, and I think that what they have submitted is a correct statement, and I'm asking the charge.
Says the defense. Mr. Phillips.
It doesn't apply to us. That's the unfortunate part about a joint trial, is you get chained to another individual, in the sense that mere presence is not our issue. So if they want to charge that, that's fine.
No, they do want to charge it, so.
We do, Your Honor, and just so everybody's clear, and I know Your Honor has it in front of you, it's a combination charge. It has mere presence and then rolls right into the hand of one is the hand of all language. But it is clearly set out in the request.
And there's no objection to this requested charge by the defense, is that right? No. Okay. Back to the first requested charge. You both have submitted requested charges concerning malice. You wanted to comment on the state's request first?
Your Honor, as was stated to you earlier when we were talking about this, and not so much in the context of the request to charge, but we had a very lengthy discussion with an objection by Mr. Phillips as to the law under Muzon and implied inferred malice with respect to the indictments themselves. So we would basically rely on that same argument. What we did was take this straight out of both Muzon and State versus Wilds.
Okay, let me pose a different question. Is there an objection to Mr.
Yes.
Phillips's requested charge?
Yes,
of
sir, there
malice?
is.
But tell me where, I printed your, I have it, yes, sir. Tell me what language in his requested charge you object to.
Judge, the first few paragraphs, it starts out with malice as hatred, ill will, or hostility towards another person, and then goes on to talk about the intentional doing of a wrongful act without just cause or excuse. The problem that I have is that is say a typical shooting case, but if you had some sort of shooting case or some other murder like that, that might be appropriate. But when you have a murder that is based on the malignant recklessness, and I think Mr. Phillips under, I want to say it was State versus Wharton, talked about extreme recklessness, that there is a different type or different proof of malice that can exist, which is the reckless disregard for the safety of others. So the fear is, Judge, in this case, I think what everybody understands the case to be about is the state of mind of Rita Pangalangan and Larry King as they did this, and whether their actions and their behavior constitutes, whether it be malignant recklessness or extreme recklessness under the statute. I believe either would support a murder charge. So, and even if you go to the second sentence of the charge, the request to charge criminal, Judge, and this is straight out of Muzon, is the second sentence of that, which talks about.
Second sentence of what?
I apologize, Judge. Let me find the exact quote in Muzon for you.
No, the second, are you referring to the requested charge now, or are you off to something else?
Yes, sir. It's the second sentence of state's request to charge one. In the context
It's
of
the
murder.
defense's request, defense Pangalanga's request.
Yes, sir. I apologize. I'm just trying to reference it in relation to why we're asking what we are charging. And the correct law of malice, as we think it should be applied in this case, would be that ill will or hatred is not required to be directed towards the individual injured. And I think that's clear law under Muzon and its progeny. So to say that malice is hatred, ill will, or hostility towards another person is, based on the evidence in this case, we believe would not be a correct recitation. That would be my first issue with it. And then that is repeated on page 2 of 13, where it says malice defined. It basically says the same thing. Maliciously means with hatred, ill will, or hostility toward another person. And that is not required, especially if you were going under a theory of malignant or extreme recklessness. That would be the state's issue with that definition of malice, and why we are requesting it, the language under Muzon in our request.
Now tell me again about Muzon that you
Yes, sir.
referred.
So the
First tell me
language-
the site for Muzon, unless you have the case to give me.
Yes, sir. State versus Muzon is 231 South Carolina, 655.
That's MOU?
1957, Your Honor.
MOUZON?
I'm sorry.
The spelling of it,
Yes, sir.
MOU.
MOUZON.
1950?
1957, Your Honor.
Oh, goodness.
And I believe that was handed up when we were having the argument on Mr. Phillips' motion as it related to the indictment, Your Honor.
relates to that particular point, what's defense Pangalangan's response?
That is the proper charge, that malice is not looked at in a vacuum. As it goes through, it explains what malice is, and that it can either be proved, expressed, or implied.
Yeah,
There-
that's the second or third paragraph of the requested charge, referring to the very first sentence.
And that's describing what malice is, and then the other part describes how it can be inferred. So they are separate, but you can't have it in a vacuum. They want to have just the inference language, but actually take away the actual definition of malice. The other definition allows the inference of it. And so it's not in a vacuum. And this language is from the old standard book. I mean, and again, with the cases they're citing, it uses the word malignant to try to describe that. And malignant is a hatred, ill will, or hostility. It is an inference that can be done through that second part. And I have no issue with that as long as it's all together in conjunction and not
We're
separated.
going line by line, paragraph by paragraph on the charge. The State v. Muzan, which is quite interesting considering the location that the case stems from and who it involves, from 1957. Citing State v. Hayward, it takes us further back, I imagine, in history. Held in State v. Hayward that malice as an essential ingredient of murder does not necessarily import ill will toward the individual injured. Your first requested charge says malice is hatred, ill will, or hostility toward another person. The state is objecting to that language, those words. What is the defense Pangalangan's position regarding those words?
Regarding the initial definition,
Regarding the
Yes.
sentence that I just referred to.
that it's a proper charge, Your Honor.
All right, so what is your response then to the statement in Muzan citing Hayward that says malice does not necessarily import ill will toward the individual injured?
That the 2002 case, State versus Watson, that I provided is the appropriate definition for it. So what you have with the ill will is more of the explaining what express malice is, whereas Watson gives us the language for the inference of malice, that a jury may infer it, that malice and recklessness are not equivalent, that extreme recklessness can lead to an inference of malice. Malice may be referred from an act so reckless as to manifest the depravity of mind and disregard of human life. That, to me, is the appropriate language. It's from this century and explains what the potential inference of malice could be done as far as what the jury can infer, but the other explains what express malice is, and it's not in a vacuum. The jury needs both to understand malice at the heart of it.
Any further comment, Mr. Lloyd?
Yes, sir, Your Honor. First of all, I would disagree respectfully with Solicitor's point in argument where he says we've all agreed what this case is about, that it's about mental state or whatever phrase he used to phrase it. In Mr. Solicitor's opening statement, he made it real clear that his theory of the case was that there was hatred, ill will, or malice toward this child. He told the jury when they watched the videotape that they would see Mr. King bring this child out of the house and throw her in the back of the car like she was so much baggage. And he told the jury, ladies and gentlemen, that's what she was to them. She was just baggage. And he went on with his argument or with his presentation to say that she needed to be put out of the way. I believe he used the language to be got rid of. Certainly this would lead to an implication of jury could infer that there was ill will or malice toward this particular child. So I think the argument that somehow we all agree that there's no indication of malice toward this child falls by the wayside, because I don't. And my concern is that the jury would believe there was some sort of malice or ill will toward this child. And if that's the case, then in fact this is the correct statement of law. And even if that is not the case, this is the correct statement of law. I do not have an objection to the language that they've requested in conjunction with the language that is in the typical charge that you provided to me kindly prior to the commencement of the proceeding today. But no. If he wants us to come in and say, oh, we agree, nobody's going to say there was any ill will or malice toward this child, I disagree. I've already heard the solicitor state the exact opposite. This is a correct statement of the law, and we're entitled to have it read to the jury. Thank you. And it's not just because it's a correct statement, but also because it applies to the facts here. With the allegations, the statements, the accusations that this child was just baggage and was thrown around like so much baggage and then left to die in the back of the car, certainly a juror could interpret that or infer malice toward the child from that. Thank you, Your Honor.
And defendant Pangalangan will agree and will join into that argument as well.
I'm going to charge the standard definition of malice. That includes the statement, malice is hatred, ill will, or hostility towards another person. It's the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. So I'm including the defense's request at the first portion of the request. Then proceeds, malice of forethought may be expressed or inferred. Do not mean different kinds of malice, but the manner in which may be shown to exist, direct or inference from the facts and circumstances. That entire paragraph accurately states the law. I do not use examples, so that portion about lying in wait, I'm striking. And that covers that part of the requested charge. Proceeding to this next part of extreme recklessness as inference of malice, what's the state's response to that?
Your Honor, I believe we would renew our motion to charge our language when we're talking about the inference of malice, that malice can be inferred from conduct under Mouzon. I would also point out next to that is that we have under that is also a quote from State versus Wild, which is a 2003 South Carolina case, also earlier handed up to Your Honor, but I can give you the site.
All right. Well, the request by the state, malice can be inferred from conduct that is so reckless and wanton as to indicate a depravity of mind and general disregard for human life. In the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant recklessness of the lives and safety of others, or a condition of mind shows a heart regardless of social duty and fatally bent on mischief. What does the defense say about that further definition of how malice can be inferred?
We would object to that language and cite State versus Watson as we have listed because it cites Mouzon. So our appellate court in 2002 directly cited Mouzon and said malice and recklessness are not equivalent. I think the language listed in Mouzon is dangerous, can be confusing to the jury, certainly prejudicial, impairing Ms. Pangalangan's right to a fair trial. It is cleared up through language of this century. Malice and recklessness are not equivalent. Extreme recklessness can lead to an inference of malice. Malice may be inferred from an act so reckless as to manifest depravity of mind and disregard of human life. I think the language is plain and easy to understand for the jury.
says defense defendant King.
I think the state's requested charge is an accurate representation of the law. and I'm not-
I'm going to include the word extremely reckless, where it says so extremely reckless, and that covers everything I believe Mr. Phillips has been saying about State v. Watson.
Yes, sir.
All right. Yes, sir.
Not trying to jump ahead, Judge, but the next section of that is the section for State versus Wiles, which is the bottom part of our request.
Well, let's see. Well, I think this, that bottom portion is included in the, let's see. Malice may be inferred, malice may be inferred from conduct showing a total disregard for human life. That's a standard charge.
Yes, sir.
So that's all of this is pretty much a standard charge, except for this request to include this extremely reckless as a criteria for inference of malice. All right. What else about, so we've covered the state, we've covered murder. And now the next request involves criminal intent. Any objection to that requested charge by Mr. Phillips?
Yes, sir. I do not object to the first paragraph, and the best way I can describe it is a paragraph. The first paragraph that runs through what does criminal intent mean in the law. Criminal intent is a state of mind, that paragraph, Your Honor. I think that's the standard charge, and I have no objection to it. I do object to the next section, which says intent means intending the result which actually occurs, not accidentally or involuntary. Intent may be shown by acts and conducts of the defendant. I think the first part of that under criminal intent is the standard charge, and I think that covers it.
All right, Mr. Phillips.
The second part of the language, I pull that out of, again, the old standard charge book that used to be provided by court administration. I understand that maybe the second sentence being duplicative, but the first, it came from the original charge book, been charged to many juries in the past. I believe it's appropriate law to say that that's the appropriate explanation.
Mr. Lloyd, any comment on any of that?
I believe the proposal is a direct statement of the law, and I'm asking the charge.
Let's see. Well, the state must prove criminal intent as part of proving any crime intent. So let's see. In order to establish criminal liability, criminal intent is required. Criminal intent is always a matter to be determined by the jury from the circumstances surrounding the situation. No way to prove intent to a mathematical certainty, no way to medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from circumstances shown to have existed This is how you make a determination of whether it exists, may be established by direct and positive evidence. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact taken into consideration. The acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant or defendants intended to do based on the circumstances shown to have existed. Criminal intent can arise from actions or failure to act. It may arise from negligence, recklessness, or an indifference to duty or to consequences that is considered by the law to be the equivalent of criminal intent. That's the standard criminal intent charge.
State has no objection to that charge, Your Honor.
I can throw in the word extreme wherever I use the word reckless.
Thank you, Your Honor.
If that's,
You were reading my mind, and the next part would be that criminal intent must be proven by the state beyond a reasonable doubt. Would be, again, and then the language that we have of intent means intending the result which actually occurs, not accidentally or involuntary. Also had the third paragraph, Your Honor.
the first portion I read says criminal intent must be proven by the state beyond a reasonable doubt.
Oh, I apologize, Your Honor. So we're on the same page there.
Print that intent for me. Thank you.
And so as far as the language intent means intending the result which actually occurs, not accidentally or involuntary?
Yeah, that's included.
Yes, sir. And then the third paragraph, I cited State versus Rowell. In a criminal case, the state cannot rely on civil concepts of negligence and recklessness, that is, statutory violations, to meet its burden of proving the defendant's state of mind. The imported terms of negligence and recklessness as used in the civil law and in the criminal law are neither equivalent nor interchangeable.
I don't think I need to get into talking about civil concepts with the jury.
That would be our objection, Your Honor.
I think the standard, I think the charges I read is adequately covers intent.
Yes, sir.
Okay. The duties of trial, of jury and trial judge, that's, I don't believe you altered that one any.
That's the standard stuff.
No objection, Judge, from the state. I think your standard charge covers that. I read through this, and it appears to be the standard charge, but, I mean, that's, obviously, you're going to charge that in every case, so we don't object to that being charged.
Circumstantial evidence, this is the updated,
State versus Logan, Your Honor.
the two words that changes it, which are those two words? All of the circumstances, is that it?
That's part of it, yes, Your Honor. And I know I have to make sure I pursue this State versus Logan charge, or I got an issue down the road there. So.
Well, yeah, well, you mean beyond you mean, is that on regarding circumstantial or? All right.
As far as explaining circumstantial
All
evidence,
right.
that's right.
Yeah, they changed two words, and I keep forgetting which two words they changed.
Your Honor's on.
All of the circumstances, all right. Mere suspicion, the Phillips's request, is that the same as what the state requested? Or, no, mere presence is what
We
you...
have mere presence, yes, sir. Judge, we don't object to mere suspicion. I think that's actually included in the general charge somewhere. I don't remember, to be honest with you, where it is, but it usually, mere suspicion, however strong, is not enough to sustain a conviction. So I don't have any objection to that language. I think it's in the general charge as well.
All right, well, I'll include it somewhere.
Yeah, I'm not on, for better or worse, I'm not on Mr. Phillips' mail list. We're gonna have one moment. Circumstance.
while they're perusing that regarding the verdict forms, any objection by the state or the defense?
No, sir, no objection from the state.
None, Your Honor.
Yes, Your Honor.
Okay.
I sent the email to you in reviewing the State versus Green case, the 423 SC 263, the one homicide, one punishment rule case, dealing with multiple offenses, including multiple homicide offenses. Although they may be prosecuted in a single trial, you have principles inherent in double jeopardy and due process preclude multiple punishments for the same offense. And as reading that case, it appears, at least my position is, that the jury, if the state's theory is that it's recklessness as far as the murder, and then we have this competing theory.
Extreme recklessness.
Oh, you see, of course. Extreme recklessness, Your Honor. And so with that being said, under murder, as far as an inference of malice, when we're looking at the next charge, the infliction of great bodily injury, that's a willful, intentional act. The reason we run into again, as I said, specifically the theory of criminal liability does not satisfy the elements of both statutes because the state is pursuing a single theory of liability. The jury can infer malice from the defendant's extreme reckless disregard for human life, whereas the infliction of great bodily injury, whereas the infliction of great bodily injury statute requires a willful, intentional act. And so with this competing set of theories, essentially, or in elements that the jury has to prove, or determine when reaching a verdict, that puts in a position where the verdict form should state the jury can either find the defendant guilty of murder, or the defendant can find, the jury can find the defendant guilty of infliction of great bodily injury to a child. They have.
So in effect, you're filing a motion to require the state to elect?
Yes, Your Honor. In this case, it walks through that, and it is. I'll be honest, as Your Honor knows, I know the law very well, but this is a complicated case in terms of how it's broke down, and so I tried to kind of highlight in what I provided Your Honor and the state with the relevant portions of that case to hope clarify this issue, because I do believe we potentially have this issue before the court.
All right, let's see. So I guess you're referring to something you sent me, and when did you do that?
Well, I didn't want to send it at 2:30 since you commented on that the other day. So this was.
Well, that was only in relation to telling me you'd be ready for closing at 9:30 rather than being ready to do more argument.
Well,
But we're beyond that now.
11:35.
Okay, that's all right. Proposed jury instruction. You're now telling me that something about the verdict form that you object to. And you've now explained all the law that's the basis for your objection, but what is your specific objection to the verdict form?
Yes, Your Honor. So specifically that the verdict form would instruct the jury that they can either find the guilty defendant or find the defendant guilty of murder or infliction of great bodily injury, but not both. And that's why we don't have murder and abhand charged at the same time. We're running into that same, because the infliction of great bodily injury somewhat mirrors abhand, and that's why we don't have murder and abhand charged at the same time. But in this case, we have murder and infliction of great bodily injury, and then the single theory of liability that's provided by the state is recklessness. The infliction of great bodily injury is a willful, intentional act. So now we have this competing issue. I know, Your Honor.
Well, it does bring in an interesting point, because I don't know that anyone has submitted a proposed charge on great bodily injury on a child. Have you all submitted a requested charge on that?
This is just the statute itself. We have referenced the statute to you on that, which is 16.395 subsection A.
No, that was. Did we talk about that?
Yes, sir, and that was in the document. This was the entire conversation I think we had the first day before we started.
Let's see. State submitted a requested charge regarding malice, voluntary intoxication, conspiracy, and mere presence.
Yes, sir. We didn't, not a special, I did not, I assume Your Honor is going to charge under your general what the law is, of the particular statutes, but the statute is referenced in the indictment.
And there's an objection to the court charging this statute, which would mean that the state must prove beyond a reasonable doubt that the defendant, well, the statute says unlawful parent, guardian, etc., person responsible to a child's welfare, to knowingly to allow another person to inflict bodily injury on a child. Gross bodily injury means bodily injury which creates a risk of death or which causes serious or permanent disfigurement or loss of impairment of bodily function. May not be construed to prohibit corporal punishment or physical discipline, which is not relevant here. It does not apply to traffic accidents, which does not apply here. So the essence of it, the state would have to prove beyond a reasonable doubt that the defendants knowingly says knowingly to allow another person to inflict great bodily injury on a child, or to inflict great bodily injury on a child. So,
And that is subsection B, and we didn't
Yes.
charge that. We charged subsection A. It's unlawful to inflict great bodily injury upon a child. And then that goes, now, of course, the great bodily injury is defined in subsection C, in which you put, there's a substantial risk of death, which causes serious or permanent disfigurement. So that's the section that we charged. And in fact, in the indictment, we actually have direct references to subsection A.
and the defense's objection is that there's a conflict with murder versus great bodily injury as being, you've stated that objection.
That's correct, and I think Your Honor was correct when they said basically what you're doing is asking the state to elect, and I don't believe we're in a position of having to do that. The Green case, which is what they cited, is two homicide statutes. This is not a homicide statute. It is it's unlawful to inflict great bodily injury upon the child, and the substantial injury is then defined as potentially something that would cause a permanent loss of impairment or even death. And in this case, of course, that was the conclusion of this. So what you've got is you've got two separate statutes, just the same as you have the conspiracy. Now you have three separate statutes. You do not have two homicide statutes as you did in Green. And so then the question is, do we have to elect? And the law in South Carolina, I'll hand you up, State versus Reynolds. I got this motion, I'm sorry, I had this motion, unfortunately, this morning, so I'm sorry I didn't get this to you earlier.
Yes, sir.
But in that case, which is a federal district court case, but it talks about South Carolina law and specifically references the issue of election. Page 7 of 12 of that opinion.
Your Honor, do I have a copy?
There you go.
Thank you.
And the issue, just to make sure we're clear, we go to the second set of paragraphs over to the right of this, and the court says, and it's about halfway down toward the end, when several offenses charged grow out of the same transaction, then the process.
Let me catch up with you.
I'm sorry, yes, sir.
On the right-hand side, have most,
It's about,
is in the middle of a paragraph.
yes, sir, and it's right before the blue section starts under State versus Lee, because actually those are all the cases that the
Several
district court is
offenses.
citing. Yes, sir.
That's all you, go ahead.
So when several offenses charged grow out of the same transaction, then the prosecuting officer is not required to elect, and the court instructs the jury to pass upon the several counts separately and write their verdict accordingly, which I believe is proper for you to do. Obviously, you have to explain to the jury that each one of those indictments are separate. The only difference is I think they included them in the same indictment. We have 3 separate indictments. So I think the law in South Carolina is clear. You have distinct offenses in this. If you even analyze it under double jeopardy, which is, I think, basically part of this as well, it doesn't apply either. So I think Your Honor charges to the jury, you have to pass upon these indictments separately and make decisions separately upon them.
Anything further on that issue?
No, Your Honor, I've marked the email as well as the Green case as a defense exhibit. It's there with the requested charges, and it's also marked as an exhibit. We stand firm on the arguments presented.
I don't know if you need to mark a case as an exhibit. The law is
Just
it's
marked.
automatically an exhibit.
Absolutely. It's just marked with my email.
All right. Yes, sir.
Your Honor, only that I join in that motion on similar arguments.
Yeah, I agree with the state on this issue. In effect, the defense is saying, well, you cannot prove malice or intentional killing, and so if you recklessly cause injury, you cannot be guilty of that. Based on the fact that the state's theory is to prove that the injury was as a result of extreme reckless. I agree with the state. The jury may find the defendant not guilty of murder and guilty of great bodily injury. The jury may find, given the facts presented, that great bodily injury was caused and then also death was caused. And the criminal conspiracy was engaged in causing all of this. So I deny the motion, and the argument is respectfully noted.
Thank you, Your Honor. And with that, I would respectfully request that the willful intentional language be attached to the statute of infliction of great bodily injury, because I believe that is a correct statement of law. So the jury is not confused by the arguments and the law as it relates to the inference of malice with recklessness, whereas the infliction of great bodily injury is the willful intentional act. That language be included to make sure the jury understands, because unfortunately the statute is silent on it, and I provided the law as far as State versus Freeland, and then some persuasive authority from our sister state of Georgia, showing that when you have no mens rea listed in the statute, the default is regular intentional criminal intent, willful intentional act. And that language to make sure that the jury's not confused on the law, that what the state's arguing to prove murder is actually not the same state of mind that is required to prove the infliction of great bodily injury to a child.
Anything further?
Yes, sir. Judge, the state would object to the insertion of something being required willful, the insertion of that into the statute. That's not what the statute says. With your Honor's permission, you may have already read it, Judge, but I will hand that up to your Honor. This is 16-3-95, if I may, Judge.
No,
Thank you.
I had them printed just a moment
Yeah.
ago. All right, I'm not going to alter the statute. I think criminal intent in general covers whatever mens rea is needed in order for a crime to be committed, and it's adequately included in the jury charge. I'm not going to modify the statute.
Thank you, Your Honor.
And to be clear, does that in any way impair my ability in closing to make that argument?
You can argue whatever you want to,
Thank you, Your Honor.
as I suspect you will.
Your Honor,
Yes, sir.
during the discourse, Your Honor referenced or read from subsection B of the great bodily injury
Yes, sir.
statute. I don't know if the court's going to treat that as a lesser. Is the court intending to charge subsection B? That's my question.
Well, I wasn't looking at the indictment at that time. I'm going to charge what he's been indicted. They have been indicted. They've been indicted in subsection A. That's the one I will charge.
Thank you.
It's not, I'm not going to charge subsection B. That's not the charge.
I understand.
All right. Okay, y'all ready? Ready for closing arguments?
I need a little bit of a break.
All right. How many minutes?
10,
All right.
10, 15? Just a short recess, Sean. Take a moment.
If you take a break, I'm leaving.
We're going to take a break.
Thank you.
We're going to take 10 minutes and we'll be ready. Is that enough time for the state? Take 10 minutes and we'll be ready to close in the presence of the jury and then Find that thing. Hey, you may bring the jury. Get this to, welcome back. You may call your next witness.
Defense restaurant.
All right, ladies and gentlemen, you've heard the defense's case. Any reply by the state?
No, sir.
All right, ladies and gentlemen, you've now heard all of the testimony. You've now received all of the evidence. It's now time for closing arguments. If you will give counsel your attention, first by the state.
Please, Court.
Yes, sir.
I'm going to talk to you very briefly today about what we know, what evidence we've heard, what testimony you've heard, what you've seen, from everything on the video, to the chemical analysis, to the experts, to everything. What I want to talk about right now is just what we know. There's the question. We start with Cristina. Cristina was a child born with cerebral palsy. She could not walk. She couldn't grasp. She couldn't talk. She could show emotion, because you've seen, for instance, this photograph, you can see the child can show emotions, and that's going to be relevant in a few minutes to what I'm talking about. But Cristina was not like other girls. She was totally dependent, 100%, on other people. She was dependent on everybody, for somebody to take care of her, somebody to give her food, somebody to give her water, somebody to keep her safe. Cristina was totally dependent on Rita to do all of those things. Every day. Every day. Not just on Rita's good days. Not just on days when Rita is posing for photographs. Not just when Rita is sober. But even on the days when Rita chooses to go hang out with Larry and get high on meth. Cristina was dependent upon her then too. Wholly dependent on her. Even when Rita was high. And you heard testimony from defense witnesses, and they came in and they told you what they knew. One had not really had much contact with her for 18 years, except through Facebook. Her daughter came in and said what a daughter should say. She's a good mother. But neither one of them knew about the meth. Neither one of them. And we know on that day, where none of those witnesses were, they didn't know what was going on. On that day, on that weekend, on that Friday, that Saturday, the Sunday, and the Monday, we know that they were on a meth bender. We know it because we took their blood. You know it because you had chemists, 1, 2, 3 chemists come in and tell you that. Methamphetamine in both Rita's blood as well as Larry, and all well over the limit that would make them high. And if you didn't, for whatever reason, think that was enough, Larry told you the same thing. He didn't want to, but he did. He hadn't slept in 3 days. He and Rita had been doing meth. She liked to put it in her coffee. And he didn't want to tell us, but he did. And we know that. And that little girl was dependent upon Rita to take care of her, to keep her safe. Rita was high. And neither her daughter knew about that, nor the other lady that testified. But we know that. Without any shadow of a doubt. What else do we know? We know that Larry had first of all, we know that in the middle of that bender, Rita and Larry get in Larry's truck and go get the child and bring her into that environment where they're getting high. And they go in and they stay the night. And we now know that Larry had a security system, a very good one, a very sensitive one, a one that would pick up any type of motion going in and around the car. And we know, because there's direct testimony, that there was no motion around that car at all until 11:15. And 11:15, the motion we saw with these two going to the car. So what do we know? The car's not on. There's no air conditioning. Nobody's been near that car. Unless the angle was that they parked the night before and left the car running with the air conditioner on. But nobody said that. Larry said, oh, the car was running when we put the child in. Because Larry needed to say the car was running when we put the child in. Not because it was true. And you know, because you could see it. The car went on. There was no air conditioner on. And they left the child in that car for 1 hour and 15 minutes before there was any more motion, before there was any more interaction with that car. We know because of, lift these back around. We know that as of about 11 o'clock is when, about 12 o'clock is when the heat starts spiking inside the car. We know that because we actually brought an expert, Dr. Grunstein, to come testify to you about what happens inside a car when it's that hot outside in August in South Carolina. And this spike starts right after 12 o'clock. Until then, it's about the same as the car. So you're talking about 80, 90 degrees to begin with. And by the time they go back to that car at 12:15, Larry doesn't go back to the car, but Rita does. We're already over here. The heat inside that car is now approaching 100 degrees. And now I want to go back to this. And first of all, let me just stop this here. If all they had done was put that child in a hot car in the middle of August and left that child there for 1 hour and 15 minutes, in some way, miraculously, somebody had come along and gotten that child out, I submit to you they still would have inflicted serious bodily injury on that child, because the definition of serious bodily injury is it likelihood that it could cause serious impairment or death. And I don't think there's any question at all what the end of this result was. If we stop there, you have that. And did they do it together? Absolutely. Even Larry testified to that. We did everything together. Put them in the car together, and you see that? We left them in the car together. And there's your conspiracy. That's not all we have. Unfortunately, it didn't stop there. Unfortunately, the child was not rescued from the people that she depended on or anybody else. So now we're at 12:15. Child has been in the 12:30, excuse me. Child's been now in the car for 1 hour and 15 minutes. No air, no wind, not even a cracked window. Now, Rita goes back to the car. She opens both doors. She opened both doors with the air conditioners on. She's opening both doors, maybe let a little wind out of there, which is the only considerate thing she did in this entire thing. Do you know what else she did? She looked inside the car. And now I want you to think about something. Go back to Christina's picture. This child can show emotion. She can't scream and she can't talk, but she can show emotion. You can see it in her face. So what did she look like when her mother was looking at her after being left in a hot car by herself with no wind in 100-degree heat for 1 hour and 15 minutes? Read to see when she looks in the car. Child's got to be going, oh, that's not a happy face in that car. After 1 hour and 15 minutes of this heat in that car by herself, a child who's totally dependent on others, she's begging for help. So what does Rita do? She closes the door and goes back inside with Larry. First time, she and Larry put the child in the car. And they go inside, as Larry says, to make up, to have sex. So while they're inside having sex, the child is out in the car. She comes back out, looks at the child at this point had to be begging, she closes the door and goes back inside to spend some more time with Larry. Which, by the way, would be the last time anyone approaches that car to look after that girl until 3 o'clock in the afternoon. They go back on the porch. At 3, no, not this one. They go back on the porch about an hour and a half later. They don't actually walk out into the car. They can go see the car. It's been another hour and 15 minutes. They go back out on the porch. They hang out on the porch. And now it's 2 o'clock, 2:02 to be exact. Neither one of them approached the car. The girl is still in there. And what's going on inside the car now? Now it's 2 o'clock, 11, 12, 1, 2. Take a look at the temperature inside that car now. It's now reached that maximum temperature. It's getting closer to that maximum temperature. It's well over 110, 115 degrees inside that car. And they come back out. And do they go check on it? No. What do they do? They hug. They kiss. And then they go back inside for another hour and 15 minutes. The child is literally cooking to death in the car, and they're going back inside again. And they stay in there for an hour and 15 minutes. And then they come back out. This time, Rita actually walks to the car. This is when she finds that the keys are locked in the car. But pay very close attention to this. Where does Rita walk when she walks out of the house? It's now 3 o'clock. The child has been in the car since 11:15. The heat is now at well over 118 degrees. Inside the car, it feels like 135 degrees. You've heard testimony from experts giving you that testimony. And where does Rita go? Does she go to the side that the child's on to check on her? Is she trying to get in the car to drive? No. What's she doing? She's going to get her cigarettes. In the back seat of the car, where they put this child at 11:15, there was a bag in the back seat. Right beside the child. And inside that bag was this. A gun.
Renewed objection.
And not only,
401, 403.
May proceed.
and not only was it a gun, it was a loaded gun.
It's overruled.
Again, in a bag, right beside this child. And right there, also, are the cigarettes. She walks back out to the car at 3 o'clock. She's still not going to check on the child. She's not even going to drive away. She's going to get some cigarettes. And she finds that the car is locked. So what do? The car is locked. The child has been in the car since 11:15. It is now 3 o'clock in the afternoon. It is well over 118 degrees inside that car. It feels like 135. They have found that the keys are locked in the car. So what do? Naturally, they break the window. No, they don't. Rita says it's too expensive, so I'll break the window.
Objection here, sir, if it's not vaccinated.
Let's go.
Really, Your Honor, it was sustained.
Objection is overruled.
Thank you, Your Honor. Break the window? Now. What do? They hang out. They get on the swing and start swinging back and forth. It's now 3:19. 19 minutes after they found that the child is locked in the car with the keys. 19 minutes after we know for a fact it's already 118 degrees inside the car. And what are they doing? They're swinging. Is there any sense of urgency here? Is it at any point in time they're going to say, hey, we need to take care of this child? No, we're swinging. And then what do? then let's go get a spare key. This is where the child is. And this is where Larry and Rita go to go get a spare key, which is why they don't get back for 52 minutes. The child's locked in the car at 3 o'clock. They don't get back until 4. Any sense of urgency there? Any concern for the health and welfare of that child? Did the child even cross their minds? Because they were high. And they were interested in each other. And they were interested in kissing and hugging and spending time with each other and having sex. Even the doctor talked about the increased libido as a result of being high on that. And you see it in all these pictures, because that's what they're concerned about. Not an ounce of concern for that child. 52 minutes. And then when they get back, they arrive 4:40. They get back to the house at 4:40. They're in Larry's truck. Thank goodness they've got a key. They can come rescue this child now. When did they get out of the truck? They don't open the door till 4:44. They sit in the truck for 4 minutes and talking and hanging out. Again, no concern for the child whatsoever. They're just hanging out in the truck. And eventually they get out. And they approach the car. And when they do, neither one of them are sober enough to even figure out how to unlock the car. Larry testified, I'm pushing the unlock button, but it's not unlocking. It's because he's locking it. He's locking, he's unlocking, he's pushing it. And the testimony that you heard from CAPT CHAPMAN, but also from even Larry, pushing the button and the light's coming on when I'm pushing the button, but it's not unlocking. And what you know is that when it's hit the emergency flasher, it's going flash, flash, flash. But at the end, when it goes blink, 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 that's hitting the lock and the unlock. I think it's once for lock, maybe 2 for unlock, I don't know. But the point is that you can't do that if the car's on. But we already do that. You know how you know that? Because otherwise, if you spend 5 hours in the car in South Carolina driving around with your air conditioning on, we would all be dead. Clearly the air conditioning wasn't on. They may have thought it was, but clearly the car wasn't on, the air conditioning wasn't on. And why do we know that? Because the child cooked to death. That's why. And also something else. Not one piece of testimony, not one person, not one came in here and said, I turned the car on. Larry said, the car was already on when I put the child in there. Although we know that's not true. Did Larry say he turned the car on? Nope. What did Larry say? I turned the car off. And we'll get to that in just a second. So they get the child and they pull the child out of the car. What happens then? Oh, and by the way, one other thing too. If they haven't gotten the child out of the car yet, they can't figure out how to unlock it. It's now 4:47, and they're back to hugging again. That's not a distraught picture because they haven't pulled the child out of the car yet. They're still hugging and kissing. They still haven't focused on the child. And eventually we get the child out of the car. And what happens after that? They pull the child up. They pull the child out. Larry calls 911. What does Rita do? She leaves. When Hallie Godley gets there, Rita's nowhere to be found. She's inside the house. And that's particularly relevant for what we're going to talk about in just a second. He calls 911, but before the police get there, what does he say? I reached in and turned the car off. Why would you do that? Think about it a minute. They just pulled a dead child out of the car. He he's calling 911. Police are on the way. Why does he reach in the car and turn it off? Don't want to waste gas? What? Why would you in any way, shape, or form stop what you're doing when there is a dead child on the ground to go reach in and turn the car off? You wouldn't. There's no reason for that. But there's a real good reason to reach inside that car and turn it on. And what you heard Captain Chapman say today is, when we got there, the car was running. The air conditioner was working just like it was working 3 days ago. There was no compression issue with that car, compressor issue with that car. It works. And the air was on, the car was running, but it wasn't cold inside. The air conditioner was going cold, but it wasn't cold inside that car. Why? Because Larry had just turned it on right before the police got there. Why? Because he knew he just murdered that child. That's why. And by the way, what did Rita say when they finally went and got Rita out of the house and brought her out? What did she say? Hallie Godley testified to this Monday, that was the very first witness. She said, I brought Rita out, and Rita said, we put the child in the car, I went inside to get cigarettes, I came back out, and the car was locked. That was her description of what happened. Even Rita didn't say the car was on with the air conditioner running. Because that would have been the very first thing out of her mouth, if that was true. Instead it was, oh, this was just a matter of seconds. I went inside to get cigarettes, I came back out, and the car was locked. That was it. Because Rita didn't know they had the camera system. Thank goodness they did. Because we wouldn't know any better. But we do know better. The child wasn't just in the car for a split second. The child was in the car for 5 hours and 42 minutes. It's an awfully long time. Everything I have told you so far, you know. No issue about it, just we know. I think we'll heard about that. So you know what happened. The question is before you now is, what do you call it? What is it? You know what it is. You've seen it. You've heard the testimony. The question is, what do you call it? Putting that child in the car to begin with, leaving that child in the car, exposing that child to potential death, was the infliction of injury to that child. It rose to the level of substantial death. The first charge, they did that early. The conspiracy, they did everything together. What about the rest of the 4 hours that the child was in the car? What about the pain and the suffering that that child had to endure before they died, as Dr. Talis testified to you? We expect at 105 degrees that people start dying. We've all had fevers. You know how bad you feel at 100-degree fever or 101. Child's inside temperature was 110. And Dr. Talis said, I'll be honest with you, I think at 104, 105, the brain stops working, the organs start shutting down. She vomited into her throat. She defecated in her diaper. You see that in the crime scene pictures. Her whole body just stopped working. And I'll be honest with you, I wouldn't expect her to last more than an hour in those conditions. And they put her in those conditions for 5 hours and 42 minutes. So we know about the infliction of serious bodily injury. We know about the conspiracy. What do you call the child's death? Well, murder is the unlawful killing of another with malice. What does that mean? Unlawful killing of another, that's pretty easy, but what's malice? Well, there are 2 ways to show malice. One is expressed. If you walk up to somebody and say, I hate you, I'm going to kill you, I don't care if you live or die, you shoot them in the head, that's expressed malice. This case is about implied malice. And what is implied malice? Implied malice is that you can take from the facts and circumstances of the case, what you have seen, what you have heard, what you know about this case, that someone was so extremely reckless that they had a wanton disregard for human life
toward that one individual, but their attitude, their actions, all of the things that they chose to do, all the way they chose to act, all led back to a conscious disregard for the lives of others, and in this case, the other person was Cristina, a child totally dependent on them for safety. A wickedness, a depravity, malicious. And we know what malicious is. And so I ask you, as you go back and look at all this, at what point in time in any of this did either one of these two people show an ounce of compassion or care or concern for Christina's life? If they had walked up to her and shot her, she wouldn't have suffered the pain that she suffered in this case.
Consider relevant and inflammatory.
Matter of law at the appropriate time.
Objections overruled.
Thank you, Your Honor. 5 hours and 42 minutes of suffering. You see the blisters on her legs, the burn marks from her coming in contact with other parts of that car that was also rose to the level of 118 degrees or 135. She was burned externally and internally. What do you call it? Well, I'll tell you that if you're sitting around talking to your family members or your friends and you're describing this situation to them, you may not talk in terms of legal anything. But I think a good way to describe this is torture. John was tortured. Before Larry and Rita, after Larry and Rita. Not the Larry and Rita that these other people didn't know, the Larry and Rita that were high on meth. And these bruises and these blisters that Dr. Vitalis described, torture. And you don't accidentally torture somebody. You treat them with such a lack of disregard for their human life that they die because of the torture. And that's what happened in this case. In the real world, you're talking to fans or family, and you're describing all of this. You might use the word torture. But in this courtroom today, they ask you to use the word murder. Thank you.
Boy, yes, sir.
Thank you, Your Honor. Good afternoon. Good afternoon.
Solicitor, in his comments to you, said a bunch of stuff, and some of it I agree with, and some of it I don't. I'd like to remind you at the outset that a moment ago, in the midst of his remarks, what he said was, and I wrote it down, they may have thought that the air conditioner was on. That's what he said. I will tell you right now, when you have heard the judge explain the law in this case, and you apply it to the facts that you've heard here, that sentence alone means the murder goes out the window. We'll talk about murder in a minute, but please, if you think nothing else about that opening remark, remember that the solicitor has conceded to you that Mr. King may well have thought that the air conditioner was on in that car. Now, ladies and gentlemen, I'm here on behalf of Mr. King. My remarks to you were addressed solely as relates to Mr. King. Ms. Pangalangan has a really good attorney, smart guy. He's going to address you soon as relates to her. So again, understand, I'm not talking about the two of them. I'm talking about Mr. King. Another thing that the solicitor pointed out in his opening remarks that I agree with was he said, well, this child was totally dependent upon Rita. And he said it over and over. And this because it's true. This was a child who was always going to be dependent on her mother, and her mother was responsible for her, her mother had to care for her, her mother may well have tried to do the best she could or not. I'm not talking about her, but I'm talking about the child who was completely in her care custody. There's no evidence before you that Mr. King was this child's father, Mr. King had adopted this child, that Mr. King and Miss Rita were married, and he was some sort of step-parent. He was dating her mom. It doesn't create some sort of legal bond between them or create duties that he has to do. This child is in the care of her mother, and he's visiting with her mother on that particular day. Ladies and gentlemen, when y'all return to the jury, when the judge is charged you on the law, suggested or instructed that you commence or begin your deliberations, it may be that if y'all reach Mr. King's indictments first, they can simply say, looking at the laws the judge gives it to you, Larry's not guilty of the crime. At least he's not guilty of any one of these crimes alleged in this indictment. Larry didn't kill anybody. He didn't commit a murder. He didn't cause grief bodily injury to anybody. And I'll talk about the conspiracy shortly. There's going to be no evidence to support that. It may be that at the outset you say, I understand why this thing's outraged. This never should have happened the way that it did. But Mr. King didn't kill him. If that's the case, I don't know if we have a four-person. But if that's the case, whoever the four-person is on the jury, you're fully entitled to this right to not guilty. Set those indictments aside and move on with whatever other business y'all have. But in the event that one or more of you feel like his circumstantial situation merits further discussion in the jury room or deliberation, I need to talk to you about a few more things, okay? First of all, the judge is going to tell you soon that every person charged with a crime is presumed innocent of any wrongdoing. And I know somebody wrote a book and they made a movie called Presumed Innocent and stuff like that, but it's an absolutely critical term of law when used in court here today. And what it means is the defendant, although he chose to testify, has absolutely nothing to prove during the course of the prosecution or during the course of his defense. And you have a right to remain silent, and that right cannot be used against you if you choose to exercise it. It's because of the presumption of innocence. It doesn't mean we'll wait and see. Maybe, maybe not. Show me what you got. It means at the outset of the trial, even at this point, you look at that paper and you say, he's innocent. It's critical. And then you look at this table and you say, okay, Mr. Solicitor, your office brought the indictment, your office called the case, your office summons law report, summons here to try the case that you scheduled. Prove to me that the defendant is guilty of the crimes in this indictment or in these indictments. And for the state to prevail, to meet that burden, what it means is they have to prove every element, ingredient, value, they have to prove every element of the crimes that are alleged within the indictment. They have to prove them beyond a reasonable doubt. So this isn't civil court. I don't know if you've done that. Sometimes you see the statute, Lady Justice, which is holding the scales and it tips a little. In civil court, it's preponderance of the evidence. It tips one way or the other, that side of things. It's not that way here. Today it is proof beyond a reasonable doubt. And the state called a murder indictment against Mr. King, alleging that he had murdered a child. It means they make you a promise as jurors that they will dispel every reasonable doubt as to every element and prove beyond hesitation that Mr. King is a murderer and that he murdered that child. I've talked about beyond a reasonable doubt. This term of art also is His Honor is going to define it for you. But a reasonable doubt, and he will tell you, I know you all pay attention to the charges, he will tell you that a reasonable doubt is the kind of doubt that would cause a person to hesitate to act. if we put aside some of what I would call the clutter or distraction in this case, and just look at what is actually relevant and what should help you in your search for the truth or in your weighing of the evidence that's been presented before you, I would suggest to you that most of what you've seen is more or less clutter, okay? I mean, the state called Dr. Grundy, the state called an expert from Georgia. He was an expert in heat. And he came from Georgia to tell y'all something that every one of you already knows. If you park a car in the direct sunlight in eastern South Carolina in August with no air conditioner and the engine not running, it's going to get too hot to live in that car. So the charts and his testimony and all this, it's filler because it doesn't give you a chance to look in Mr. King's heart, which is what you're going to have to do shortly. We conceded in our opening statement that this child was in a car, that it got too hot, and she died. I submit to you that this professor from Georgia doesn't really bring anything new to the table. You can pretty much set it aside because we know what happened. It got too hot in the car and the child died. The pathologist is the same. You already knew before the pathologist ever took the witness stand what had happened with this child. You had heard us concede that this is what happened. You had seen the videotape and this is what happened. And you knew this child died from me. Really nothing is useful to you whatsoever. They called this police officer, Captain so-and-so, and I don't know why he's back up here today. But they called him to testify to this key fob. There's been a lot of talk back and forth. But really, what was necessary to hear from him was plain and simple. It came out yesterday. He said, if you unlock the car, or you lock the car, while the engine's running, the lights don't flash. Nobody ever locked or unlocked the car with a key fob that they retrieved from Rita's house. Because as you heard, the battery was dying. Once or twice they hit the key fob, the doors didn't unlock, the lights flickered, and then they didn't flicker anymore. So, fine, you lock it or you unlock it while the engine's running with the key fob, the lights don't flash. It never happened. It's irrelevant in this case. And as much as the solicitor wants to talk about methamphetamine in this case, because it's prejudicial and it's bad and people think terrible stuff, because it is a terrible drug. Much as he wants to talk about that, they're not charged with methamphetamine. And when the solicitor says the only reason that you know methamphetamine was involved in this case is because their expert came to testify to that, I submit to you that's not true. As a matter of fact, what their witness did do, the toxicologist, while I submit she gave you nothing that would help you in deciding this case. She said methamphetamine goes to the cycle, you take it in, it peaks in your bloodstream, your body processes, it goes out of your bloodstream. She says, yes, people get a tolerance to it, and I would submit to you that if anybody would have a tolerance to it based on all the evidence that you know, it's probabilistic. She also said that, yeah, Mr. King having 400, that was certainly a level to raise eyebrows or cause concern, but that she's seen it up to 2,000. This doesn't have anything to do with the charge of murder. We don't talk about that. But what she did do was give the defense, wrapped up in a nice box with a fancy bow, a gift to Mr. King. Because she said on the witness stand, under some fairly stringent cross-examination by Mr. Phillips, yes, this stuff can take up to 3 days to get out of your body. She further confirmed to him, I can't say if this is from ingesting methamphetamine that day or the night before, or if it's from 3 days before. I simply can't say that. You know, as jurors, that there's a whole lot of people who would have sat at the defense table, and that would have been the story. I took it 3 days ago, and I get on the stand, I was just tired. That was the only effect I was under. I was out from under this thing. Mr. King got to the stand, and he rejected that. He took an oath to tell you the truth. And we're hurting, potentially, or at least make the solicitor realize he has been smoking right in the family. He told me. No one else was going to tell you he was addicted to methamphetamine and drugs. No one else is going to tell you he was what's called a functional addict. That is, that he used methamphetamine throughout the day to allow him to function. He's never been without work, like disputes. Had 5 jobs in his life, like disputes. He's always been functioning, going to work, supporting himself, meeting his needs. But just as there are functional alcoholics, he was a functional addict. No one else was going to tell you. The solicitor wrote that right down. He's probably going to talk about it some more because he loves talking about methamphetamine. Why did he tell you that? Because he tells the truth. Good, bad, let the chips fall where they may. This is what happened. It's not that he didn't want you to know it's a solicitor. The only time he hesitated to answer was when they asked about me. And according to his own code, he said, I'll speak for myself. Then he answered the question in front of the boss. But the judge will soon tell you that it's up to you as jurors to judge the credibility of the witnesses as they come in here to testify. And credibility means the believability. And there's no magic formula for it, but the judge will tell you it's your own opinion based on your own experience, your own worldview. But when a person testifies, you can see that they testify consistently or inconsistently, they testify, they contradict themselves, or they supported by other facts and evidence or other evidence that's being presented. And I will submit to you that if Mr. King will come in and give the state this gift, knowing full well it sounds bad, but he's honest enough to give you that, you can certainly find he's honest enough to give you the rest. If he'll tell you the things that are bad for him and you believe him, you can probably believe him when he tells you the rest of it also. Now, the state has charged Mr. King with murder. I assume it's the worst crime there is. And murder is not hard to define. Murder is the killing of a human being with malice aforethought. First of all, as relates to Larry's case, the murder indictment fails to meet. Okay? Larry didn't kill anybody. If you recall, when you think back to the solicitor's opening argument, or opening statement, his opening statement, he says that he's going to show you the videotape where Mr. King rudely comes out with this child, the door's open, he throws the child in like so much baggage that he just wants to be rid of her, and he uses the term 2 or 3 more times. She was just baggage. I know y'all watch the tape. I said, my lawyers can't help it. We watch y'all, but I watch y'all while I was watching. I know everybody paid attention. Everybody was involved in the evidence. So, on behalf of Mr. King, thank y'all for that. But you didn't see that. What you saw, it's in evidence. You see it again if you need to. Was Mr. King come out, as he described, appropriately, properly, gently, maybe lovingly, but certainly appropriately, gently, appropriately. Place the child in the back seat. Move the child to put her in the proper position and be comfortable. Step back. Rita stepped up, put the seatbelt on her, did whatever she was doing. She did what she needed to do to have the child settled into the car. That's all Larry did in this case. That is the sum total of what he did. He relinquished this child into the arms of her mother. He stepped away. I got feelings hurt, heartbroken the way he described it. I'm out, and he tells her, go. You just go. Leave. I'll talk to you later. She doesn't leave, obviously. She goes back and forth. But at that point, the solicitor would need to prove to you, hold on, that when Larry King put her in that car, he did it with malice. First of all, he's got to prove that putting her in the car made efforts to make sure she was safe and well and properly positioned in there. And then he's got to show that when Larry did that, when he put that child in that car, he did it with malice. That he killed her, and he did it with malice. What does malice mean? I'm going to read it to you. Sorry, but I'm going to read it to you. Malice is hate, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstance from which the law will confer an evil intent. That's what malice is. So before you can even consider whether or not Mr. King should be convicted of murder, you have to consider whether or not there's any evidence whatsoever to make you believe he put that child in that car with hatred, ill will, hostility, or the intention of doing a wrongful act. And that's nonsense. And y'all met Mr. King. Y'all met him. Y'all had a chance to judge his credibility, his believability, and to determine whether or not you think he's innocent based on everything you've heard and everything you saw, whether or not the state has proved beyond any reasonable doubt in your mind that when he put the child in the car, he did it with hate, ill will, and malice. And it's nonsense. Further, malice can mean a general malignant recklessness for the lives and safety of the others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. And all of that's real strong language, and there's a reason for that. It's because it needs to be. It's the worst crime that there is. And if Larry actually walked out and put the child in the car with the intention of the mom driving her safely away, and then he stepped away and said, y'all go, and he doesn't do anything else to this family, there's no indication whatsoever of malice, hatred, or ill will. And without it, the murder indictment falls on him. It falls for element one, killing someone, and it falls for malice, because he didn't kill anybody, and there's no indication he had any malicious, ill will, ill intent toward this child. That's what the state promised to do. Ladies and gentlemen, in your jury room, excuse me, in your jury room, you will have the indictments, and there are 3 indictments Mr. King is called to answer to. Murder, and I'll address that. Inflicting great bodily injury on a child, and the arguments will be very simple. And a conspiracy charge. When you have those indictments in your jury room, you are fully entitled to look at them, examine them, and see what you think about those documents. You may notice, if you look closely, that shortly after this child died, Mr. King was indicted for murder. Period. Stop. And then as time went on, and a trial went, and the rubber's going to meet the road, we're going to put it to the test. Somebody looked at that murder indictment and said, this ain't gonna fly. It was 2.5, maybe 3 years later, coming in for the trial, they came up with new charges. And that's just the look at the dates. Look at the dates. They got all this fire in their heart, absolute confidence in this murder case, we've proven that, etc. Why are you coming around at the back end and trying to get a fallback position? You know why. It's because there's no evidence of malice whatsoever. There's no evidence that killed anyone. That indictment goes by the wayside. The arguments as to inflicting great bodily injury upon this child are the same. Mr. King placed the child in the car. At that point, she's not in his house, she's in the car. Mom can get in the car and drive away. Mom can get in the car and drive 100 miles an hour. Mom can put a walk. She can do whatever she wants to do. She's not his child. He is not responsible for this child. He is not the one who needs to take care of this child. He steps away and says, y'all just go. She's off his plane, so to speak. He didn't hurt her. He didn't cause her to be hurt. As a matter of fact, as the solicitor conceives, he thought the engine was running, the air conditioning was going, and she was off his plane. He'd seen nothing in the previous past background to cause him concern that she wasn't able mother was there. And her mother had a child. And as the solicitor stated, she'd always ride on Rita. And I'm not shooting at Rita. That's a different, not on my plate. But she relied on Rita. Only one person was responsible for the child that day. And it wasn't Mr. King. Now, that would bring us to the conspiracy charge. Mr. King is also charged with conspiracy. I told you at the outset and got admonished for it. I don't know what the conspiracy to do with it. And the indictment doesn't say. It doesn't say conspiracy to commit murder, conspiracy to cause great bodily injury to this guy, but a conspiracy. Okay. I'll assume, or I'll go with, that means he must have conspired, because the solicitor made a point of saying how they acted together, everything they did together. Well, he must have conspired to murder this child, or he must have conspired, excuse me, to cause great bodily injury to this child. I'll tell you what conspiracy means. His Honor's going to tell you shortly, but just so I don't get it wrong. Conspiracy is defined as the combination between two or more persons for the purpose of accomplishing a criminal or unlawful object, or an object either criminal or unlawful by lawful. So basically it means conspiracy is defined as the combination between two or more persons for the purpose of accomplishing a criminal act. So he's alleging that Mr. King has conspired with someone to murder this child. Now, if you look up the word purpose, Google it, it'll tell you it means intention. The judge's purpose here today is to rule on matters of law and ensure that the defendants get a fair trial. The judge's intention here today is to rule on matters of law and ensure that the defendants get a fair trial. So, we can substitute that word and say a combination between two or more persons with the intention of accomplishing a criminal act. So, I told you at the outset this was a garbage indictment. It is. Certainly, even the state is not going to get up here and tell you that they have established evidence that shows Mr. King and Ms. Pangalangan somehow got together and decided, how are we going to murder this child? How are we going to hurt this child? How will we kill this child together? The law says they come together for the purpose or with the intention of accomplishing a crime. And it's absolutely devoid of any evidence that shows Mr. King ever intended to commit a crime. I'm almost done. Now let me do this, and then I'll sit down. Let me do this. Take you back to this tape and consider it this way. Blank slate. You watch this tape, and Mr. King walks out with his child in his arms. He places the child in the car. He steps back. Stay with me. He has a conversation with Rita. You need to go, etc. And then he turns around, he goes to the back of his house, he drives away. He's upset. He goes to the brother's house, he goes wherever he wants, he turns and he drives away. And then the events unfold exactly as they did here, without him being at his house. Is there any way he's committed a crime? Is there any way he exhibited malevolence, ill will, or hatred? Is there any way whatsoever? And the only answer is no. Well, the only difference between the scenario I just described and what took place is that in this case, he was present in the trials. He didn't do anything different. He was just present. His Honor will soon tell you that you cannot be guilty of a crime merely by being present in the trials. When Mr. King's undying regret already continued guys, he was present when the crime was there, if you all determined. But he did no more in reality than he did in that scenario I just described.
Thank you.
Ladies and gentlemen, we're going to break for 45 minutes for lunch. Please do not discuss the case if you'll go to the jury room. Take 45 minutes.
Your Honor, right before we break, one of the things, since this is televised on 14B and on crime and all these news stories, before we send the jury back, I would like Your Honor to poll them to see if they've happened to watched any of that or come across it, just to ensure if we need to have somebody stricken. Just as a fail-safe, Your Honor. I don't know. I want to make sure that's asked.
Okay, we'll do that.
Thank you.
Okay. 45 minutes. bring the jury. They're ready to come. We actually don't need it, but it's close. Mr. Phillips.
Thank you, Your Honor. As a parent, this case is hard for me. I have 3 little children, and I know it's hard for you. I said it in open. The raw emotion that you feel, I'll be candid. I'll put my cards on the table. It's anger. I can't watch the video and not yell, please break the window. It's anger. I have to be candid with it. And I know you feel the same. I told you that in open. I'm not running from it. This case is what it is. There's the video. But after reviewing what we have in the evidence and the video itself, this case is a lot of it, but it's not murder. When you separate that, my job is much easier than yours. I'm an advocate. Your job is harder. You've taken a sworn oath before God to separate that. And that's hard. That's not something normal people have to do. You have to separate emotion. You'll hear from the judge and instruct you on the law that passion, prejudice, hatred, any of that stuff that comes up in this trial, those raw emotions, you have to set that aside. And you have to base your verdict solely on the evidence that's presented on that witness stand and admitted through everything that we've seen. But when we do that, it's not murder. It's a lot of things, but it's not murder. You swore to give her a fair trial and not base your decision on emotion. Now, I'll give you every right, because it's natural, it's human nature. In this courtroom right here, you can be as angry as you want to be. You can be angry, you can have those natural feelings, 'cause we all know it's natural. However, and I can't stress this enough, when you cross the threshold of that door and walk in that jury room, you have a sworn oath that you are separating yourself from that. Your job is hard. But you took that oath, and you have an incredible responsibility. That when you cross that threshold, you have to separate that and apply just the law. And again, I'm not saying it's easy. It's not easy for me. But we've all seen it. And in this case, the government's done a lot of different things, and we'll touch on that. But I just can't stress it enough. I have to say it again. Be angry now. Have that emotion. But you can't let it cross that threshold and go into that jury room. You swore not to do that. And if somebody in that jury room starts talking about that kind of stuff, or starts talking about TVs and all this other stuff that's improper, I empower each of you to come tell the judge, because that is not what's supposed to happen. That is not the law. We're going to follow the law in this courthouse. And it's not easy. It's not easy. But that is the law, and that is your sworn duty. Now, depraved heart murder, this malice, this extreme reckless disregard for human life. The government has went painstakingly to say, well, that's easy. Well, let's walk through that. Today, I showed you on this Defense Exhibit 15 that's been admitted, they put an officer on that stand the first day. He was unequivocal that the light won't flash if that car's running. Turns out he was there and it can flash. And he can come up with any explanation he wants. But the facts are the facts and the video's the video, just like the video you gotta watch. It's tough. And they gotta own this video just like we gotta own that video. They can't run from it. And I want you, if you have any questions about it, watch it for yourself. It's short and it shows what he said and what was unequivocal and what they would have argued if I didn't do that. They would have said there's no way that car was running. And then you hear for the first time today from him that the car was running when he got there. You didn't hear that from Ms. Godley, that first witness. You didn't hear that from him until now when he's backtracking. Why? They want that murder conviction so bad. They got the cameras. This is their spotlight. They're going to make the news. They're going to send a message, right? That's not your job. Your job's not to get caught in that. You leave that anger in this courtroom and you decide this case on the law. In that. Now, we see Rita go to the car at, they said 12:15, I think it's 12:29. But again, you have all the time in the world and it's your show once you get the case. You can watch the video as many times as you want. You can go through any parts. I empower you. Any not sure what somebody said, Madam Court Reporter can pull it up for you. We're not running from the facts of this case. They are what they are. But Rita goes to that car, and there's only 3 scenarios. And they intentionally, I think, left this out, and I'll just say it. They said, well, she opens both doors. Right before that, again, what does she do? She comes out, she opens the front door. She sits in that car. And we know she sits in the front door for a period of time because the camera skips. That means there wasn't motion. So we know she sat in the front seat of the car. There's only 3 scenarios. She sat in the front seat for a period of time, and the car wasn't running, and she left it that way. I submit to you, that's a depraved heart murder. If they both believed that car wasn't running and the air conditioner wasn't on, they're right. That's depraved heart. But the solicitor conceded that they might have believed that the air conditioner was running. But we also got testimony today that the car was running. She didn't hear the day before. That's strange. They then tried to flip it that Larry turned it off, or turned the car on right beforehand. And you heard this extra testimony from Officer CHAPMAN. But again, you watch the video, anybody that does a push button start a car, you got to push in the brake to cut the car engine on. Guess what he doesn't do? He doesn't sit in that car and push it. He doesn't, leans in and hits the button. Why would they do that? Also says, Rita doesn't know they have a surveillance camera. Their own evidence shows that in his bedroom, where they say Rattlers is what they contend, There's the surveillance camera videos. This is their evidence. This is what they brought. And he's switching it up in closing, saying she doesn't know anything about it. Also their evidence. The surveillance camera itself, sitting right behind the swing. Rita doesn't know there's a surveillance camera. That's the solicitor's words. He's going to have to own this. They want this conviction back. They want you to use emotion. They want you to be angry. That's not what you're going to do. I know you're not. We chose you all for a reason. Because you swore to do that and follow the law. Facts are the facts. They can't run from them. They try to show this gun. Where's that picture of the gun? The gun had nothing to do with this case. If they truly believed it was a murder based on the facts they presented, why are they trying to show some gun? It shows the weakness of their case. They're just trying to inflame you and get you more angry. What's the purpose of the gun? Now, my position is this. They knew they had a problem, and 3 years later they did the infliction of great bodily injury because they knew they had a problem with proven murder. Why else add that charge? This case is a lot of things, but it's not murder. They knew that, and that's why they added that indictment. Now, you'll hear that reasonable doubt is kind of defined in two ways. That you're firmly convinced of something, or it's something that causes you a hesitation to act. And that's important because I like to describe, defense lawyers have a hard time trying to always come up with a way to describe legal definitions. But this is how I like to do reasonable doubt. I say you consider it a voting booth. Very similar to going back to a jury room. You got to make a decision. You got two options, non-guilty and guilty. Under the law, Rita is presumed innocent. That not guilty button is already pushed. Now the state has to prove beyond a reasonable doubt of all the elements, malice, this depraved heart, based on the evidence, that you don't have any hesitation to hit that guilty button. If you have any hesitation, you'll hear the judge himself tell you, if you have any hesitation, that's a reasonable doubt in the law. She's not guilty of murder. If you're firmly convinced, no hesitation, you're 100% sold, there's no doubt that they thought that car was running an AC, that's a brave heart. We own that. Anybody that would do that, it's on its face. Now, you're entitled to your own opinion. Don't be swayed necessarily by other jurors. You're entitled to your own opinion. The law gives each one of you your own voice. Don't let other jurors bully you into a position that you don't feel comfortable with. Stand firm. And I'm not saying one way or the other, but you stand firm in your convicted beliefs. That is what the law requires, and that's what you should do. Again, you're a chosen jury. It's not random. You came here, that was random, but each one of you was chosen. I used 10 strikes, I think. They used 8 strikes. We chose you for a reason. We chose you because we knew that you could be fair and impartial, that you would follow the law. It's an incredible responsibility that you have. It's not random. Each one of you were chosen for a reason. Come here. We've been sitting over there in the corner. I had to bring her right here in front of me to look you in the eye. You heard from her daughter that she's a loving mother, that she was there for her family, that all this other stuff about dirty house and food, all this stuff that they try to say is the murder from that video, they threw in all this other stuff. Bed bugs, dirty house. Her daughter, the one that's there, the one that's a teacher, the one that's part of the pastoral part, married to a pastor, all the people here in attendance, saying exactly what you needed to hear, right? That the lady, that you saw how she acted, that she didn't pay rent, that she brought her boyfriend and kids in there, and was dirty, messed up the house, and she got kicked out. She had an axe to grind. But why present all that if this case isn't what it was supposed to be? The murder's on video is what they're trying to say. They're trying to say it's so open and shut. Then why are they adding all this other stuff in there? This is real. This is no high school debate. This is no round table discussion. This is this woman's life, this woman's freedom. And I'm not saying that she did everything right, because God knows, I already said she did. And you can be angry in here at Rita, but you can't do it in there. Now you've been given, as I said, an incredible responsibility. One that almost nobody has. You heard the judge tell you out of all the United States and the state of South Carolina, you were chosen. There's only 3 people I know that can judge another person. That awesome power of judging a person. That's you as jurors, the judge with the black robe, and the man upstairs. You have been given just an opportunity in your life, one that's the most difficult decision of your life. I understand. We put you in a tough place. But it is an incredible responsibility. You're sitting in judgment of another person. There are no do-overs. You wake up tomorrow, you have your breakfast or your coffee, and you think, did I make the right decision? It's too late. There are no do-overs. You can't wake up 10 years from now, 30 years from now, 50 years from now, wondering, did I make the right decision? There are no do-overs. If you have doubts, you have them now. You have them in that room. You be confident in your verdict. If you have any hesitation about hitting that guilty button, that's reasonable doubt, and that is not what you're supposed to do. Any hesitation, firmly convinced, the depraved heart, that they had no belief that they put those kids in that car with that Cristina in that car with that air gun. No belief. They firmly convinced it was the depraved heart. You got to be sold on that. I'll just end on this. There are no words. There are no excuses. Just the law and your sworn oath to find her not guilty of murder. They gave you the answer 3 years afterwards. Tell them what the answer is. Thank you.
Mr. Stone.
Thank you, sir. The defense wants you to believe that because they didn't get together and say, let's kill Cristina, there's no malice. Unfortunately, that's not the law. That's not what the law is, and that's not what the judges could tell you. The judges could tell you this. That malice can be inferred from conduct so reckless and wanton as to indicate a depravity of mind and a general disregard for human life.
And renewed objection.
It's not going to be,
Objection's overruled.
thank you, Your Honor. It's not going to be the malice that they're trying to say has to exist. That they got together and said, let's kill Cristina. The bottom of this, malice does not require ill will toward the individual. What does it require? Actions and conduct so reckless as to show a disregard for human life. So the question you have here is, what did they do to show a disregard for human life? And the answer is, everything. Everything. You want to know what's relevant about the loaded gun in the back seat? That's a disregard for human life. As the first defense attorney got up here and said, everybody in South Carolina knows you put a child in a car
that's in direct sunlight in August, and you leave them there, they're gonna die. Right. That is a disregard for human life. In fact, it would be actually better and easier if you went through and tried to find a sign at which time they actually showed you some regard for that child's human life. But you won't find any because it's not there. It's not there. Larry's defense attorney came up here and basically said this. Well, just like the solicitor said, he may have thought the air conditioner was on. Right. Because he was high. Because he was high. I don't know what he was thinking. I think if any of us watch this video, the one question that has to pop in your mind over and over and over again, what are you thinking? What are you doing? You put this child in the car, and you know nobody's been in the car, you know it's not on, there's no air conditioning, you're in the middle of summer, you're in South Carolina, everybody knows you're not supposed to. What are you doing? What are you thinking when you find the child locked in the car at 3 o'clock that afternoon? 4 hours later. Let's don't break the window, let's go find another key. What are you doing on the swings? What are you doing when you're going inside and having sex and the child is still out in the car cooking? What are you doing? And there's no answer to that. You know why? They're high. And what the judge is also going to tell you is that voluntary intoxication, voluntary use of drugs is not a defense in South Carolina to anything. To anything. If they're high and they think the air conditioning's on, so what? They're high. And by the way, the disregard for the safety of others, the disregard for human life, getting high to begin with. You go in to get your child, you continue to get high. You put the kid in the car while you're high. You can't find a single thing in this anywhere that shows that they care 1 ounce about that child. Did I say at the very beginning that that child was baggage? The child was baggage on that day. Did some witnesses take the witness stand and say, she's been a good mother in the past? But no one knew about her nephews. None of them knew how she acted when she was high on Beth or Larry. None of them did. They didn't lie to you, they just didn't know. And they said they didn't know. Larry says, okay, I got another defense. Not my child. Never mind, he put the child in the car himself. He wants to pass because it's not his child. He's not responsible for the child. Because he doesn't have any regard for human life, her child, or anybody else's. Supposedly, if I saw something going on with a child, I'd do something about it, would you? What about 3 o'clock in the afternoon? The child's locked in the car. Break the window. That's Larry. What about me? They gave a big deal about Brittany Honeycutt. What did Brittany Honeycutt tell you? She said, take this child with you. Please take this child with you. I got to go to work. I can't take the child with me. Take her to work, put her in the car, leave her there. That's what I do. I do it all the time. They said, well, Brittany Honeycutt didn't like her very much, and she didn't like Brittany. Okay, fine. Let's go to Lindsay Lewis, the babysitter. The same babysitter that Rita abandons her child with 3 days before this takes place. The babysitter who'd never taken care of the child before. The babysitter who didn't even know that if the child ate solid food, that there was a choking hazard because Rita never told her. The same babysitter who came in and testified there wasn't any food in the house, and she just left. And all Saturday I tried to call her and she didn't respond. You know why she didn't respond? Because she was getting high with Larry. Her focus was on Larry. Her focus was on getting high with Larry. Not anything to do with this child. She didn't respond then. She didn't respond before. She didn't respond to this entire event. Not to that child. All of her concern, Larry. She abandons the child with the babysitter. Then she turns around and puts the child in the car. They don't forget it. Just like I said in my opening statement. They didn't forget her. They stood around the car until they went inside and had sex. Where was the child? In the car. It's abandoned the child again. Yeah, I own the fact that I said baggage. It's exactly how they're treating that child. Baggage. In the way. Because she needed to be with Larry. She abandoned the child then. And the child's locked in the car. Does she stay with the child? No. She and Larry go and hug and kiss in the car in the truck and they take off. It's abandoned the child again. And one more thing and I'll sit down. Mr. Phillips brought up an excellent point. He said he's a parent. Lots of his parents. When she finds that her child is dead, I'm a parent. Imagine finding my child dead.
Objection, Your Honor.
Just like Mr. Phillips said.
Objection is,
Speculation is improper, it's not in evidence.
the objection is overruled.
Thank you. Can't imagine. Most parents, they find their child dead. They're not going to be inside the house when the police get there. In fact, the police are going to have to pry their parent off of that child. And if the police don't have to do it, the coroner's going to have to do it. And the coroner doesn't have to do it, the funeral director's going to have to do it. Because the parent is going to stay with that child. That child is dead. The child is part of them. They're never going to leave that child, even if the child is dead. And what did she do? She went aside. She abandoned the child. Maybe at some point in her life, and maybe on other days, she would have done that. But on August 5th, 2019, two people found that murdered that child. On this day, they tortured that child to death.
Madam Forelady
Yes, sir.
and members of the jury, you have heard the testimony, received the evidence, and heard the arguments of the state and the defendants. I will now explain to you the law that applies to this case. Under the Constitution and laws of the state of South Carolina, you are the finders of the facts. I do not have the right to pass on the facts or to express any opinion that I might have as to them, because this is a matter solely for you, the jury, to determine. As jurors, then, it is your duty to determine the effect, the value, the weight, and the weight of the evidence presented during this trial. As a trial judge, it is my responsibility to preside over the trial of the case, to rule upon the admissibility of the evidence offered during the trial. You are to consider only the testimony from this witness stand, together with any exhibits which have been made a part of the record. I have the additional duty to charge you the law applicable, and as the presiding judge, I am the sole judge of the law. It is your duty as jurors to accept and apply the law as I now stated to you, then deliberate in an effort to reach a verdict. I charge you in that regard that you should not be concerned with what you think the law ought to be, but what I tell you that the law is. Now, you are also the judges, the sole judges of the credibility, that is, the believability of the witnesses who've testified and of the evidence offered during the trial. In considering credibility, you may take into consideration many things, such as the demeanor or manner of testifying, whether the witness had reason to be biased or prejudiced, and whether the testimony of a witness was contradicted on the one hand or supported and corroborated on the other hand. You may believe a small portion of a witness's testimony and disregard the larger, or vice versa, these things you will consider, bearing in mind that you should give each defendant the benefit of any reasonable doubt. It becomes your duty as jurors to analyze and to evaluate the evidence and determine that evidence which convinces you. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by direct evidence or circumstantial evidence. The law makes no distinction between the weight or the value to be given either direct evidence or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, all of the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray a defendant's behavior as suspicious, the proof has failed. The state has the burden of proving each defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Now, the rules of evidence ordinarily do not permit witnesses to testify as to opinions or conclusions. An exception to this rule exists for witnesses who are called expert witnesses. An expert witness is a witness who, by education, experience, has become an expert in some field. And that witness may state an opinion to relevant and material matter within their expertise. And they may also state the reasons for their opinion. You should consider any expert opinion received in evidence, and like any other evidence, give it the weight that you think it deserves. If you decide that an opinion of an expert is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of any other witness, simply because the witness is an expert. Further, you are not required to accept an expert's opinion even though it is not contradicted. Now, I instruct you and emphasize that the fact that a defendant did not testify is not a factor to be considered by you in any way in your deliberations and in your consideration on the question of the guilt or innocence of a defendant. It must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. So I repeat, under your oath, you are to draw no conclusions whatsoever from the fact that a defendant did not testify. The fact that a defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated, is on the state. The defendant is not required to prove him or her innocent. The burden remains on the state to prove guilt beyond a reasonable doubt. Now, the fact that the defendants were arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does an indictment create any presumption or inference of guilt. The indictments are simply the formal written instruments which contain the charges made against the defendants. The indictments are the formal documents by which this case is brought into this court. Each defendant has pled not guilty to the charges in the indictments. And those pleas put the burden on the state to prove the defendant or defendants guilty. A person charged with committing a criminal offense in the state of South Carolina is never required to prove himself or herself innocent. I charge you that it is an important rule of the law that a defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies each defendant throughout the trial until you reach a verdict of guilt, satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of a defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It's not just a legal phrase. It is a substantial right to which every defendant is entitled, unless you are satisfied from the evidence of proof beyond a reasonable doubt. The state has the burden of establishing every fact necessary to prove each defendant guilty beyond a reasonable doubt, because the law presumes every defendant charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. So what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt, therefore, is proof that leaves you firmly convinced of the guilt of a defendant. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are convinced that a defendant is guilty, then you must find him or her guilty. If, on the other hand, you think that there is a reasonable possibility, a real possibility, that either or both of the defendants are not guilty, then you must give each of them the benefit of the doubt and find him or her not guilty. The indictments in this case allege 3 separate offenses against each defendant. The indictments are murder of Cristina Pangalangan, great bodily injury on a child, and criminal conspiracy. Each indictment charges a separate and distinct offense as to each defendant. You must decide each indictment separately on the law and the evidence applicable to it, uninfluenced by your decision as to any other indictment. Each defendant may be convicted or acquitted on any or all of the offenses charged, and you will be asked to write a separate verdict of guilty or not guilty for each indictment. The defendant Rita Pangalangan and the defendant Larry Eugene King are charged with the murder of Cristina Pangalangan. The state must prove beyond a reasonable doubt that the defendant or defendants killed Cristina Pangalangan with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury, or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant or defendants just before and at the time the act is committed. Therefore, there must be a combination of the previous evil intent and the act. Malice aforethought may be expressed or inferred. These terms, expressed and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which expresses hatred or ill will for another, or when the person prepared beforehand to do the act which was later committed. Malice may be inferred from conduct showing a total disregard for human life. Malice may be inferred from conduct that is so extremely reckless and wanton as to indicate a depravity of mind and general disregard for human life. In the context of murder, malice does not require ill will toward the individual injured, but rather it signifies a general malignant, extreme recklessness of the lives and safety of others, or a condition of mind that shows a heart regardless of social duty and fatally bent on mischief. As to the charge of great bodily injury on a child, the state must prove beyond a reasonable doubt that the defendant or defendants inflicted great bodily injury on a child. Great bodily injury means bodily injury which creates a substantial risk of death or which causes serious injury or permanent disfigurement or protracted loss or impairment of a bodily function, member, or organ. As to criminal conspiracy, the state must prove beyond a reasonable doubt that the defendants combined together for the purpose of accomplishing a criminal or unlawful object, or an object neither criminal nor unlawful by criminal or unlawful means. To establish the existence of a conspiracy, proof of an express agreement is not necessary, and direct evidence is not essential, but the conspiracy may be sufficiently shown by circumstantial evidence and the conduct of the parties. Now, in order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, extreme recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. And criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says criminal intent may be shown from circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established in the same way as any other fact by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. It is up to you to determine what the defendant or defendants intended to do based on the circumstances shown to have existed. Criminal intent can arise from action or failure to act. It may arise from negligence, extreme recklessness, or an indifference to duty or to consequences that is considered by the law to be an equivalent to criminal intent. Voluntary intoxication or use of drugs does not constitute a defense to a crime, but proof of mere presence at the scene of a crime is not sufficient to find someone guilty. However, the law also says that the hand of one is the hand of all. If a crime is committed by two or more persons who are acting together in the commission of a crime, then the act of one is the act of both. When a person does an act in the presence of and with the assistance of another, the act is done by both. As indicated, mere suspicion, however strong, is not sufficient to sustain a conviction. Suspicion implies a belief or opinion as to guilt based on facts and circumstances which do not amount to proof. Now, while the arguments of counsel are a beneficial part of every trial, you should remember that the statements made by counsel are not evidence. In presenting their arguments, counsel often refer to the evidence. However, you should base your verdict on the evidence as you remember it. If there are any conflicts between the recollection of counsel about the evidence and your own recollection, you should rely on your own understanding of the evidence. And Madam Forelady and members of the jury, I'm required to charge you the law as I've done through giving you these instructions, and that's to help guide you to a just and lawful verdict. Whether some of these instructions apply will depend upon what you find to be the facts. The fact that I've instructed you on various subjects must not be considered as indicating an opinion that I have as to what you should find to be the facts or what your verdict should be. Now, you've been chosen and sworn to give the parties a fair and impartial trial. When you've done so, you will have complied with your oath, and no one will have a right to criticize your verdict. You must not be influenced by opinions or expressions of opinions you may have heard outside of the courtroom, but rather should base your verdict solely on the testimony of the sworn witnesses who took the stand, the exhibits received into evidence, and the law which I have stated. You should not be swayed by caprice, passion, prejudice, or improper sympathy for or against anyone. Remember, you have no friends to reward or enemies to punish, and all parties are entitled to a fair and impartial trial. It is your duty as jurors to consult with one another and to deliberate in an effort to reach an agreement. Each of you must decide this case for yourself, but only after an impartial consideration of all of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and to change your opinion if you become convinced that it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. As I stated earlier, you are the judges of the facts. Your verdict must represent the considered judgment of each juror. In other words, your verdict must be unanimous. And Madam Forelady, it will be your duty to preside over the deliberations of the jury. If during your deliberations you should desire to communicate with me, please reduce your message or question to writing, signed by your foreperson and the foreperson only. Then pass the note to the bailiff, who will bring it to my attention. I will then respond as promptly as possible, either in writing or to have you return to the courtroom. However, I caution you, with regard to any message or question, that you should never state or specify your numerical division at the time. You've heard the evidence, and now you have heard the law. Whatever your verdict, Madam Forelady, you will indicate the verdict on the verdict form. And we have two verdict forms, one for Pangalangan and one for King. And as to each charge, the verdict is either not guilty or guilty, you would check the appropriate box, then sign it at the end. Now remember that although only the foreperson writes the verdict, it is not hers alone. The verdict has to be unanimous. And Madam Forelady, you're not authorized to write the verdict until all of you have agreed on the verdict. So ladies and gentlemen, I'm going to send you to the jury room to start deliberating in a moment. But when you get there, don't begin deliberations until you've received a copy, until you've received the copy of the verdict forms and the exhibits. And once you receive these things, that will be your signal to begin your deliberations. Once you begin your deliberations, you will deliberate until you have reached a verdict, at which time you'll knock on the door, advise the bailiffs, and we will bring you out to receive your verdict. Now, we've selected 14 people to serve on jury duty. First 12 regular jurors and then 2 alternates. Before asking any question about whether you can continue with deliberations, want to inquire of the jury whether anyone has made an effort to contact you about the case, or whether you've viewed any media articles or been otherwise exposed to any other information about this case other than what you received in the courtroom. If you've seen or heard anything else outside of the courtroom or been contacted by anyone concerning the case, if so, raise your hands. And no hands are raised. Now, if we have 2 alternates, 2 very capable alternates over there, if for any reason any of the first 12 of you selected cannot continue with deliberations, please raise your hands. So all the first 12 jurors are good to go, which means that the 2 alternates will not be able to participate in the deliberations, and when they go to the jury, if you all will hold your position right there. So I'm going to send you to the jury room now and wait for the verdict form and the exhibits, and that will be your signal to begin your deliberations. So please go to the jury room. Will they close the door? Is that door closed? Are there any additions or exceptions to the charge?
No, sir, none from the state. None, Your Honor, thank you. None from the charge, Your Honor. Whenever the appropriate time is, at the matter of law, hearing, closing, you can put that on the record.
All right. So if you all then can review the exhibits that's going back to the jury, along with, we're going to pass up the verdict form to them as well.
Does Your Honor send the indictments back or just the jury?
No. And while they're reviewing these exhibits for submission to the jury room, I'm going to discharge alternates now. I don't know that you have to take that down. Or if you do.
Yes, sir.
Oh, okay. Start taking it down.
Oh, you want, I'm sorry, did you say
Yes,
yes or no?
yeah, may as well, yes.
Yes, sir.
Let's let the alternates go, then get back to that. To the two alternates, thank you all very much for your efforts during this trial. Whenever people appear for jury duty, they're quite often hesitant and hopeful that they don't get picked. But almost everyone who gets selected to be on the jury, by the end of the trial and during the course of the trial, they become heavily invested in the trial and they want to see it through to its conclusion. So I've noticed you all being very attentive and very good jurors. But the luck of the draw, the first 12 selected are those folks, and you all were standing in the wings ready to join the jury if you needed to. So we're going to release you from jury duty now. I would suggest that you not discuss what you think the verdict should be until you hear from the jury as to what the verdict is, at which time you're willing to, you can talk to anyone that you might want to about the verdict at that time.
Just say thank you. Thank you for your time.
And I want to thank you on behalf of all the parties and your other fellow citizens of Colleton County. And so you're excused, Madam Clerk. Any other comments for the jurors? Okay. You normally tell them that you're going to send them a check or all right, I've got you. You don't explain the checks anymore.